Okay.
I have my very own.
This is the regularly scheduled meeting of the Sunshine Ordinance Task Force, called to order at 4:40 on Wednesday, September 2nd, 2015. Mr. Young, would you call the roll, please?
On the call of the roll, Member Wolf.
Present.
Wolf present. Member Copra. Copra absent. Member Pilpil.
Present.
Pilpil present. Member Hepner.
Present.
Hepner present. Member Haynes. Haynes absent. Member Fisher.
Present.
Fisher present. Member Hinsey.
Present.
Hinsey present. Vice Chair Hyland. Hyland absent. Chair Washburn.
Present.
Washburn present. We have a quorum. Regarding agenda changes, we have a withdrawal of items number 5, 6, and 8 on today's agenda. In addition, we have a continuous request on the next item, file number 15008, complaint filed by Brian Brown against the San Francisco Public Utilities Commission for allegedly violating Administrative Code Section 67.21 for failure to respond to a request for public records in a timely and or complete manner. The complainant has submitted a request for continuance. I would like to state that the complainant has previously requested continuances for a meeting scheduled for two previously scheduled meetings.
All right, so our policy has been or has become that we automatically grant even a last-minute request for continuance requested by the complainant. We've now had several requests for continuance. So what we've done in these instances is we've tabled the matter essentially, which is tantamount to closing the item, closing the file. So, but we do have someone here from the PUC. I think we should invite the respondent up to the podium for.
I have a.
Yes, Member Wolf.
So has that become a policy or a practice or just something we're still doing on a case-by-case basis?
It's actually been proposed, gone through the Rules Committee process. It's in the draft of the new complaint procedure. And just using my recent memory of what we've done.
So it's essentially
it's become
policy that hasn't quite gone through the final process.
Right.
Yeah,
It's a practice that's about to be, that will soon be memorialized if we agree to it. Member Pilpel?
Yeah, just on the first item, I just wanted to be sure that the communication from Mr. Warfield withdrawing items 5, 6, and 8, if a copy of that can be shared with the library as the respondent, I'd appreciate that.
All right. So at this time, we have a representative from the SFPUC here. So before we possibly take a vote to table this, would you state your name and check in with us now?
Yes, thank you. My name is Deborah Chilvers.
Hold on.
Can you hear me okay?
Better.
Mm-hmm. Okay. So I am Deborah Chilvers. I'm the Deputy Communications Director at the SFPUC. Thank you for giving me a few moments of your time. As stated, this is our third appearance here before you on this item. And just wanted to state unequivocally that we did, in fact, provide all responsive documents within the 10-day prescribed period. After the last time we were here, I heard some of Mr. Brown's concerns in that he was a bit confused about which attachments went with which emails, which seemed like valid feedback to me. So in an attempt to resolve it amicably, we spoke on the phone at length about all of his questions, which I answered, and then I offered to collate everything chronologically. We wrote the names of the person who provided the feedback in the attachment, so there was no question about which email went with which piece of feedback. I provided that both via snail mail, in paper, electronically, verbally, And at that time, Mr. Brown suggested that that would be responsive to his concerns. So I'm a bit confused as to why this is continuing, and I'm also a bit concerned about the number of continuances. So it is my hope that you would consider this feedback. My personal opinion is that this should be dismissed and not continued, but I, of course, defer to your decision. Thank you very kindly.
Thank you. Does anybody have any questions for Ms. Childress? Okay. Seeing none, is there a motion to table this?
I move to table the item.
Okay, and this will mean that it's finished.
Yes, our definition of tabling is to conclude the matter.
Conclude the matter, right?
Yes.
We are not dismissing anything, we're just concluding it. Yes.
And I mean, just
Member
from, like, I don't quite understand exactly the reason that it has had this continuance process, and it does seem that the end result is we've had city staff that have continued to make themselves available for meetings. I'm potentially concerned that one could refile and then continue using continuances as some sort of tactic, which I don't necessarily have any reason to think is happening here. And I'm just curious whether tabling it is the same thing as analyzing the complaint in their absence and finding no violation, or whether there'd be any difference in terms of revisiting the matter and that sort of thing.
My thought is that we typically give every benefit of the doubt to the complainant, and if we haven't heard anything from the complainant, it's pretty hard. It can be hard to simply find no violation or dismiss it in that way.
I mean, I don't disagree with that at all. My question is specifically, and I guess it's for Victor and anyone else that can weigh in this, whether there would be a procedural difference for him refiling if we were to find no violation versus tabling it, because someone could always refile a complaint anyhow, right? Or would that change the matter?
If you made an actual decision and found no violation on a matter, we would not allow a duplicate filing on the same subject matter or the same instance.
Unless there was new information
Unless there's new
pertinent to the
information.
matter.
If we do table it, the complainant is allowed to refile at a future date, but it'll be up to the task force to decide whether or not to grant future continuances on any future filings.
Yeah, I mean, I'm in favor of the continuance. It's just something that, not the continuance, the tabling of the matter. I'm just sort of something that I'm trying to be aware of in case it should become an actual issue in the future.
Okay. Would you like to second the motion?
I'll second, yeah.
There was a second.
Oh, there was a second. I'm sorry.
Yeah.
Sorry. Okay.
Yeah.
All right. Okay. At this time,
comments.
Member Pilpil.
Just a couple of brief things. I've previously disclosed that I was a member of the PUC Advisory Committee. That changed 2 months ago. I'm no longer a member of the PUC Advisory Committee, and I wanted that to be clear on the record. Next thing, we received a communication, I guess, dated, or a series of communications from Mr. Brown in the last few days, and I just wanted to be sure that those were copied to the PUC.
Yes.
Okay. Including that he will not have the time before Wednesday to give adequate time to review, make notes, and frame a concise response, and therefore he will not be in attendance. I just wanted to make a couple of observations about this, even if we're not going to hear it today on the merits. One is that the PUC, for whatever reason, responded to the wrong email address, and they seem to have acknowledged that. And the thing that was actually most concerning to me is their use of a generic email address, public records. They certainly can do that to receive records requests. My strong suggestion to them is in responding via that email box to give the name of the person that responds. I just think it's wrong, for lack of a better word, to just get a generic response, here are the records, or we have no records, thank you, public records. It just seems incredibly impersonal to me. And so in the future, if the PUC and other departments that have those generic boxes could actually associate a name with the response, I personally would appreciate that. Those are my only observations. Thanks.
All right. Anything else from the task force? Okay, at this time.
Just one,
yes,
adding to that,
Member
I
Wolf.
mean, even if it's not that easy to switch the from box and sending it from, signing it public records coordinator, that's easy to not, to attach a name to the writer of the email.
And it may be the same person, it may be a different person, just some person. It's actually a person responding. I think it's good for an individual to get a response from a person. That's all. And I think the PUC hears that.
Yeah, I think it's unusual for us. I don't think I've seen that before, actually. At this time, are there any comments from members of the public on the motion to table this?
Yes, I'm Peter Warfield, Executive Director of Library Users Association. I'm not part of this complaint, and I'm not familiar with it at all, except to the degree that I was copied on the email, and I did have contact with Mr. Brown. I'm really quite shocked that his email hasn't been read out here, in which he explains the reasons why he is requesting I'm shocked and disappointed that his email hasn't been read here, in which he very briefly lays out why he's requesting a continuance. Now, I appreciate that you don't want to keep going with continuances again and again. I'm very troubled to hear the chair saying that we're basically fiddling with the rules that we have in the direction of rules that we don't yet have. That's wrong. Again, understanding that it is certainly costing something for the task force, the public, and the respondents to have multiple continuances, but it's my understanding from that email he had a very specific reason, and that is he did not know how to get open from your rather mysterious agenda packet. It doesn't say click here to have a link to the explanatory documents. The explanatory documents don't show what they are. And in his case, there are 171 pages in his portion of this packet. And since he is a person of advanced years, considerably advanced years, and apparently with other things pressing on him, he said there was no way in the very short time that he had where he could even see what this was all about and what was in the file, that he could prepare a response. Part of that issue is something that I think you need to realize, and that is the amount of time that the task force gives to complainants between the time that they say you're on the agenda and the time that the hearing occurs is very short. Less than 10 days. And recall, this was filed in February. So I think, as Member Wolf says, you should not table this. You should accede to his request. And as the chair says, give every benefit of the doubt to the complainant by giving a continuance. Thank you.
Thank you. Are there any other comments from members of the public? Oh, excuse me, you're a part of
Public question.
a question.
Yeah,
Okay.
as a member of the public, I was just requesting a little further clarification on the definition of tabling and what that would mean if that was the decision here.
That means we've closed the file and it will not be on the agenda again. Mr. Brown could refile. It would be a new file.
Okay,
So,
thank you.
all right. Thank you.
Without any ruling on the merits.
All right. Any additional public comment? Okay. Mr. Young, would you call the roll on this matter?
On the motion, Member Wolf?
I'm
Wolf, aye. Member Pelpel?
Aye.
Pelpel, aye. Member Hefner?
Aye.
Hefner, aye. Member Haynes, absent. Member Fisher?
Aye.
Fisher, aye. Member Hinsey?
Aye.
Hinsey, aye. Member Copra absent. Vice Chair Hyland absent. Chair Washburn.
Aye.
Washburn, aye. The motion passes. The matter is tabled. Next on the agenda, item number 3.
And excuse me, Mr. Young, you'll communicate to Mr. Brown the outcome and let him know that he
Yes, I
is
will.
free to refile, okay?
Yes.
And then he would have access to the hearing files,
Yes.
okay?
And
As he's had all along, right?
Yes, there are relatively few new documents from the previous continuance in the file.
Okay, thank you. Mr. Wolf?
if there were to be a new file, all the stuff from the previous file would somehow be attached if it came back, or
We would work that out. That has not occurred yet, and I have not developed a procedure regarding that. But
I think it's important that the record of the old file, if a new file is opened, somehow stays attached to it for review purposes and whatnot.
We've got it.
Yes.
It's not going anywhere. It can be incorporated.
it is a detail that I can work out.
Great.
It hasn't come up yet. Next on the agenda, item number 3, file number 15094, determination of jurisdiction of the Sunshine Ordinance Task Force over the San Francisco Housing Authority in regards to the complaint filed by John Kelly against the San Francisco Housing Authority for allegedly violating Administrative Code, Section 67.21. The hearing of file number 15094 is for the purpose of determining if the Sunshine Ordinance Task Force has jurisdiction over the San Francisco Housing Authority.
All right.
A quick question.
Yes.
I see Mr. Kelly here. Is there someone here from the Housing Authority? Excellent. Thank you.
Oh, I saw the hand. Who's the, okay. I saw a hand and nothing else.
All right. Members, we have the brief by DCA COLA about this matter. And so our council is of the opinion that this matter, we do not have jurisdiction over this matter, that the Housing Authority is not a city department. It is not anything that's established by city charter. Sorry.
Church?
No, it's my son. Okay. No, he's not a minister, but. So I guess I'd like to hear from DCA COLA, just if you could kind of recap what's in your memo to us.
I essentially found that we don't have jurisdiction. The Housing Authority is an entity that's created by the City and County of San Francisco, but it's spun off. It's a state agency. It's funded through state and federal means, and we don't have jurisdiction over them.
All right. Members, do you have any questions about this?
I have questions, but I'd like to hear from the complainant and the respondent. and
Okay.
then-
All right. So this is where, right now, we're not
On jurisdiction?
We're not going to hear the case at this moment on its merits. What we want to hear is your argument that the matter should be heard by our body. So the complainant, Mr. Kelly, would you speak to that issue? Why we should hear this in light of what our council has said?
Yes, thank you, and good afternoon, Task Force members and Madam Chair. I am John Kelly. I live in housing owned and managed by the Housing Authority of the City and County of San Francisco. My complaint is that the Housing Authority has refused to make a substantive response to my public records request in May of this year. That's 3 months ago. As Mr. Pilpel found out, we do have the presence of a representative of the Housing Authority here. She apparently finds time to attend this hearing, but not to respond to my public records request. In any event, the city attorney has submitted a memorandum to the task force stating his position that the task force does not have jurisdiction over the Housing Authority. I regard this memorandum as an informal opinion because the opinion lacks any analysis of the facts and law, and it just states a conclusion. I respectfully suggest that the city attorney's informal opinion is mistaken, and I suggest that this task force should be very skeptical of legal opinions lacking analysis. I am unaware of any formal opinion of the city attorney on this issue of jurisdiction. If there is such an opinion, I request that the task force produce the opinion and make it public. I believe that the city attorney's informal opinion is mistaken for the reasons stated in my position paper, which was submitted to the task force. I stand on the arguments in my position paper. In addition, I would like to supplement my arguments based on the changes to the Sunshine Ordinance by Proposition G in 1999. As you know, the Sunshine Ordinance was originally adopted by the Board of Supervisors in 1993. Since that time, the ordinance has been amended several times. The most significant amendments were by Proposition G, which was an initiative approved by the voters in 1999. For the purposes of this case, Proposition G made two significant amendments, which I would like to bring to the attention of the task force. In Section 67.3D3, the language of Proposition G, which is now the law, states, policy board shall mean any board, commission, committee, or other body created by ordinance or resolution of the Board of Supervisors. As you've heard from the city attorney, the San Francisco Housing Authority was created by resolution of the Board of Supervisors. The prior language before Proposition G was more truncated. It merely stated that policy body shall mean any other board or commission established by the charter or ordinance or resolution of the Board of Supervisors. So the authors of Proposition G expanded the jurisdiction of the Housing Authority. In regards to the public meetings law. In addition, I would like to bring your attention to the changes made to Section 67.21 of the Sunshine Ordinance by Proposition G. In this regard, Proposition G wholly replaced the language that was in 67.21 with new language. And the language now states, every person having custody of any public record or public information as defined herein shall at normal times and during normal reasonable hours of operation, without unreasonable delay and without requiring an appointment, permit the public record or any segregable portion of the record to be inspected. That's very, very broad language that extends to anybody holding public records. So, I believe that these amendments show that the authors of Proposition G wanted the Sunshine Ordinance to have the widest possible application, and that if there was any doubt concerning the jurisdiction of this task force before Proposition G, it was removed by the new language that was adopted when the voters passed Proposition G. I hope the task force will agree with me in regards to this issue, but if you do not agree, I request that my complaint be heard in accordance with your authority under Section 67.32. Thank you.
Thank you.
Oh, and I have copies of the Proposition G ordinance with the previous language that was in the Sunshine Ordinance before the passage of Proposition G. And I have 9 copies for the task force and a copy for the city attorney. If I can ask to have those passed out.
Thank you.
Thank you.
Why don't we reserve 1 copy for the Housing Authority first?
All right. At this time, okay, at this time, is there a representative from the Housing Authority here to speak to jurisdiction?
Good afternoon. My name is Linda Martin, and I'm the Director of Policy, Government Affairs, and Supervising Attorney at the San Francisco Housing Authority. I am here to respond to this complaint. The Housing Authority does believe that that this task force does not have jurisdiction. The SFHA is not a city organization or a city agency, as alluded to by Mr. Kelly, even though the Housing Authority is in the city and county of San Francisco. The Sunshine Ordinance Task Force states this clearly on their website under the frequently asked questions. The Sunshine Task Force has previously determined that this body does not have this jurisdiction over similar cases such as this one, and this situation is no different, nor is it more unique than the past decisions made. The SFHA agrees with the task force previous determinations on the issue of jurisdiction as it pertains to the SFHA and requests that a decision consistent with its past determinations be made in this complaint. The Housing Authority did sit with Mr. Kelly. I actually personally sat with Mr. Kelly for about an hour after this public records request was made. It was also made under the California Brown Act, and I did explain to him that in this particular case, what he was requesting was actually not a report the Housing Authority had, nor could it be generated. What the request that he was making needed to be what we call bean counting. Somebody's going to have to sit down and go through every single name. We have right now about 20,000 people on our wait list. Right now, the way that we're responding...
Excuse me. I think right now you're speaking more to the substance rather than jurisdiction. So right now we're trying to figure out jurisdiction.
Okay.
And anything you can tell us to help us understand that issue from your point of view would be helpful.
Yeah, so we were created by the Board of Supervisors. We fall under the California Health and Safety Code under the Housing Ordinance, and we don't fall under any jurisdiction that would force the Housing Authority to comply with the Sunshine Ordinance. So if there's any questions, I'd be happy to answer them.
What was your name again?
Linda Martin.
All right. The matters with the task force, Member Hebner.
Ms. Martin, is it your opinion that the SFHA was not created by a resolution of the Board of Supervisors?
It was, I believe, in our minutes. It was.
And how do you distinguish that from the Sunshine Ordinance, which allows us to retain jurisdiction over bodies that are created by resolution of the Board of Supervisors?
Hold on 1 second.
Or DCA COA?
So this is in the good government.
It wasn't actually created pursuant to a resolution of the board. The Health and Safety Code, which is a state legislation, allows for the creation of housing authorities by local boards, but it's not something that it's something that they can utilize in order to form a housing authority, but it's not that they enacted in their own ordinance creating an agency that they spun off.
So the California Health and Safety Code allowed for the creation of these local housing authorities, and then the San Francisco Board of Supervisors passed a resolution creating the San Francisco Housing Authority.
They opted to utilize the state legislation that was in effect to form a housing agency, but they didn't create their own resolution to form a housing authority.
Here's a question: did the California Health and Safety Code mandate the creation of these housing authorities, or was this sort of an opt-in system that the California Health and Safety Code
I'm not 100% sure on that.
Okay.
Member Pilpel, do you
If I
know
can
about
address
this?
that, and then I'll take my regular time in the queue when we get there. Exhibit C that Mr. Kelly provided to us includes the relevant code section. It's page 187 of the packet, section 34-240 of the, what is it, the Community Development and Housing section of state law. One second, which reads in relevant part,
Yeah.
in each county and city, there is a public body, corporate, and politic known as the housing authority of this county or city. The authority shall not transact any business or exercise its powers unless by resolution the governing body of the county or city declares that there is a need for an authority to function in it.
Right. So then ultimately the San Francisco Board of Supervisors, by resolution, determined that there was a need for
that there was a
authority.
need and that it could transact business and exercise its powers. But the first sentence says, in each county and city, there is a body.
I see.
And I would read that as state law creating the entity, but only allowing its exercise of powers when the board passed the resolution. And this was pursuant to the Federal Housing Act and the state law that created housing authorities generally.
Additionally, that seems like it's more of an argument to go towards saying that they're subject to the Sunshine Ordinance pursuant to public meeting laws, but not to actually records requests, which is what was made here.
Chair Washburn.
Yes, member.
Yeah,
Fisher.
through the chair, maybe this question is more for DCA COLA, but as much as I enjoy members Pilpel and Hepner, because it's very Talmudic almost, and we're so close to Rosh Hashanah, so I do like the debate and argument. Isn't this a little more, aren't we complicating this? Isn't this a little more simple? That I did want to hear what the complainant had to say and what the respondent, but the bottom line is we don't have jurisdiction on this right now, and the law is the way it is right now. And maybe it'll change, but right now we don't have jurisdiction for what Mr. I already forgot your name, I'm so sorry.
Kelly.
Thank you, Kelly is requesting.
Well,
That's a question, that wasn't rhetorical.
I mean, it's a unique argument trying to say that the language in Prop G is broad and should there be inclusive, but Prop G is an addition to what was already formed under the Sunshine Ordinance, and it clearly defines what city agencies are. And in this case, it was a public records request, so we're looking under a city department definition, and city attorney stance that this just doesn't meet the definition of a city department.
And one last thing, Chair Washburn, I mean, this isn't our first time that we've had things like this, and I think in the past we've determined if there's no jurisdiction, there's no jurisdiction.
That's true. We have determined that. I think Mr. Kelly raises some very interesting issues.
Yes, thank you.
And I really appreciate the analysis he's done for us. I especially like that you've brought the information from the voters' pamphlet from way back when. That's very valuable. Member Pilpel.
I also enjoy Mr. Kelly and his arguments very much, although I respectfully disagree with him on this, and I would like to put to bed the issue of jurisdiction with regard to the Housing Authority now and until there's a change in law or circumstance. I don't think the Housing Authority is, in this regard, any different from the school district, the college district, the San Francisco Health Authority, San Francisco County Transportation Authority, et cetera. There are other entities that are created under or pursuant to state law that have powers and duties, that have boundaries coterminous with the city, but are not part of the municipal corporation known as the City and County of San Francisco or a department thereof, and for which the ordinance simply cannot and does not reach. In fact, 67.32 was intended to recognize that these other agencies are not part of the city and that the city and its officers, employees, and agents should affirmatively seek to get public records and public meetings policies enacted at those places comparable to those required by the Sunshine Ordinance, but recognizes that they are governed separately and in most cases subject to the Brown Act with regard to meetings and the Public Records Act with regard to records. So I think our only conclusion at this time can be and should be that we have no jurisdiction, that we will not entertain future matters regarding any of those agencies that we just have no. I mean, the question of jurisdiction is the same as someone asking for public records from Alameda County or the federal government or the Golden Gate Bridge District or any number of other governmental agencies over which they're not departments of the city and over which we simply have no jurisdiction. And I think Mr. Kelly's only recourse here is to the Board of Commissioners of the Housing Authority, which meets at City Hall, I think in this room actually from time to time, or by a writ petition in the San Francisco Superior Court if he believes that his public record request was not properly responded to. So following discussion, I'm prepared to make a motion to encapsulate that. Thank you.
Member Wolf.
I mean, when it comes to most of those organizations you named there, they have nothing to do with the state. Alameda County has there's some crossover there. There's bodies that have members from our city ordinance, but in this case we have an entity that was created by the Board of Supervisors. Whether they exist in every entity and just are essentially not activated until the governing body determines to do so, that the action of catalyzing them doing something was the Board of Supervisors, and the entire all of the members are appointed by. Are they all been appointed by the mayor, or they're appointed all by part of our city apparatus? And so, it seems to me that it is essentially an app, even though it's an independent organization to some level, it still is completely made out of organizations that do fall under the Sunshine Task Force, and I see a legitimate argument for why that jurisdiction should continue there.
Okay, Member Pelpel, and then we'll
I'll just
need to
respond
move on.
briefly. Again, the mayor makes appointments to any number of places. The mayor appoints members to the Metropolitan Transportation Commission, to the Golden Gate Bridge District, to other places. The Health Authority has appointments by the mayor and certainly the Board of Supervisors. But these are all entities created under separate state laws that are subject to, again, the Brown Act for meetings and the Public Records Act for records, and are just not part of city government. This city government are not departments of the city. They may hold public records, they may hold public meetings, but they do so pursuant to those other laws, and they're just not subject to the Sunshine Ordinance. Same thing, like I said, with the school district and the college district primarily. And we look for ways to reach to the when there's a vacancy on the college board, the mayor appoints there. But that doesn't make the college district part of the city. It's just not. So I don't think there's any way that we can find jurisdiction here.
Okay.
Do you want me to make that motion?
Do we need to hear rebuttals on?
Do we hear rebuttals? No.
Okay,
Yeah.
just finding. Okay. So at this time, is there a motion to?
I would so move that we affirmatively find no jurisdiction on this complaint.
I think we don't do that. We just, there's no motion.
I think we should, it's before us, and I think we should affirmatively act.
Is there a second?
I don't even know what the motion is.
Well, then let me ask Nick, do we need to do a motion? I mean,
I think we just,
Vote on jurisdiction is a standard protocol.
right, so it's a motion.
wouldn't the motion be to, no, we always make a motion, excuse me, through the
I
chair.
don't
we-
see any restrictions
Yeah.
on how you
We've done this
word the
before.
motion.
Okay, all
Where
right.
there's a question that's come up, required a determination.
Okay,
we can
make the motion.
All right.
Do something.
I so move that we find no jurisdiction with regard to this complaint, and further that we not find jurisdiction in the future with regard to the housing authority until and unless.
Take the future thing
All right,
out.
fine. With
Okay.
regard, I don't want complaints against the housing authority to come back to us
Okay.
again. That's why.
That's up to them. People can
Okay,
have their
we
say.
will try to remember this.
Okay,
Okay. We have ways of keeping track of what we do,
excellent.
It's called computers.
right?
Motion is to find that
Do we have,
the Sunshine Ordinance Task Force does not have jurisdiction over the San Francisco Housing Authority.
is there a second?
I'll second.
All right. At this time, is there any public comment on the motion to find jurisdiction, or excuse me, to not find jurisdiction?
Hearing none? Oh.
Peter Warfield. We heard the representative of the Housing Authority say that the San Francisco Housing Authority was created by the supervisors. She said that in her presentation. And I think that Member Wolf and others have a very good concept that should be paid attention to, as well as the complainant's argument. I do have some questions, and that is, what does apply to this agency? Doesn't state law apply, and doesn't state law require openness with respect to documents? And doesn't the Sunshine Task Force have an obligation to rule on state law as it applies to, well, city agencies? I would like to read from section 67.32 and ask you to consider that as well. After a short introduction, it says, officers, agents, and other representatives of the city shall continually, consistently, and assertively work to seek commitments to enact open meetings, public information, and citizen comment policies by these agencies and institutions, including but not limited to Presidio Trust, San Francisco Unified School District, blah, 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 San Francisco Housing Authority, and so on. To the extent not expressly prohibited by law, copies of all written communications with the above identified entities and any city employee, officer, agents, and/or representative shall be accessible as public records, and so on. Finally, I would also like to urge you to consider your broader responsibilities with respect to advice to the city under Section 67.30. And 67.30, under Section C, the last sentence reads as follows. The task force shall, from time to time as it sees fit, issue public reports evaluating compliance with this ordinance and related California laws by the city or any department, office, or official thereof. And you might want to consider whether the appointees of the mayor or whoever appoints housing authority folks is a city official. So those are some things I think you need to consider here. Otherwise, what do we have? An agency that's beyond the law, and as I said, she said herself, the supervisors created our agency. Thank you.
Thank you. Is there any additional public comment? Okay, seeing none, Mr. Young, would you call the roll on the
On the motion,
motion?
Member Wolf.
Pass.
Member Pilpil.
Aye.
Pilpil, aye. Member Hefner.
Aye.
Hefner, aye. Member Haynes. Haynes absent. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Member Copra. Copra absent. Vice Chair Hyland. Hyland absent. Chair Washburn.
Aye.
Washburn, aye. Member Wolf.
No.
Wolf, no.
So that it doesn't pass.
The
So then
motion
what
does not
happens?
pass, and may I suggest that this matter will probably need to be continued to the next meeting where we have more members present, as we cannot take any action at this time.
Well, through the chair, let me ask, if we had made it no motion, it would have just gone away. Or if we had made a motion, if we had had no motion, then it just would have gone away, right?
Or if we had,
Perhaps.
or if we had made a motion to find jurisdiction that was defeated, then it would have gone away.
Well, we still need to find jurisdiction in order to proceed with the complaint. So if somebody wants to make a motion to find jurisdiction, that still needs to occur.
Okay. Do I hear a motion to find jurisdiction?
I'd like to make a motion to find jurisdiction.
Second.
Okay. Is there any public comment on the motion to find jurisdiction? Sir, you're a party to this.
Can't.
Madam Chair, you're bouncing around here, and I think I've been listening here for a long time to a lot of things I find to be inaccurate. And now you're proposing what I regard as a dishonest motion by a member of your board who's said that she doesn't think that you have jurisdiction, and that she's making a motion to find jurisdiction. I think that's highly questionable, and you shouldn't proceed in that manner. Thank you.
Okay, DC Acola, could you? No?
I won't go through the whole thing again, but again, I think I've raised some questions. I haven't heard a whit of discussion or countering or taking up any of the points that I made. The Housing Authority is mentioned in 67.32 explicitly. And it says what they shall do. It seems to me that it's up to you to determine whether they are doing that appropriately or not. And I'll read the key section. To the extent not expressly prohibited by law, copies of all written communications with the above identified entities and any city employee, officer, agents, and or representatives shall be accessible as public records. And again, your larger concern is here is a complainant coming to you with a problem about getting documents from an agency, or at least he says he's been having a problem. And I think in your broad responsibilities, you need to determine whether this is actions by the city or any department, office, or official thereof. If the mayor is appointing or the city is appointing people, is that not an official of the city? Even if that official is serving in another body. If you have a statewide group to which the city appoints members, it seems to me you've got a city official who is going to that broader agency, and therefore that's certainly something you should consider and at least, consider and discuss. Thank you.
Okay, I just want to say a couple of things about what Mr. Warfield had to say, and this is kind of off the top of my head. So in reading 67.32, this is addressing the idea that the city and county believes that these agencies should comply with the spirit of the Sunshine Ordinance, which, as you know, is stricter and stronger than either the Brown Act or the California Public Records Act. And this body could and has, I believe in the past, consulted with these other agents or these other bodies listed here to help them. Specifically, we've worked with the city, the public SF public school district, right?
School district, the college district, the redevelopment agency, the transportation authority.
So this is something that's in our purview and that we in fact have done. What we haven't done is heard complaints against these bodies because we don't see that that is part of the jurisdiction. Now, regarding any correspondence between city departments and city staffers and city officials and these bodies, those documents would be public records if they were requested from the city. Okay, but it doesn't work the other way. If you want copies of what the mayor said to somebody at the Housing Authority, you would ask the mayor's office and not the Housing Authority. That's my understanding of this. So I think I've learned a lot today, and Mr. Kelly does raise a very important issue about how we're trying to resolve this matter, and perhaps we've gone about it in a very backhanded way, as he mentioned. Member Wolf?
I think what might make more sense than moving forward with the kind of resolution that people oppose and weird, if Member Hebner could explain why you were sort of going with one course of discussion that I was following, and then you seem to have sort of come onto the other side in conclusion. And so if you could explain that, that might help me get to the same place that you're at on this, as opposed to other approaches to this.
I was ultimately satisfied that the SFHA was created by statute of the California, a state statute, and that it was not so much created by the Board of Supervisors of San Francisco, but rather a type of enacted, or as you put, catalyzed by. I don't think it was created by the Board of Supervisors.
And this is based on that, the one line that Member Pelpo raised, or is there other stuff you were researching that raised your...
Correct. And also, my caution to deviate from our longstanding precedent on this question, which I think also informs my opinion.
Because my concern is that there seems to have been numerous people saying that they were created by the Board of Supervisors in one way or the other, including the representative from the Housing Administration herself, Housing Authority herself. And we do have how a policy body is defined as including anything created by the Board of Supes, and that still feels very ambiguous and nebulous to me, and I would rather see that looked at further than to, make this sort of decision where it still feels vague to me. Maybe it's clear to others.
All right, Member Pilpel.
I'll just try again very briefly. The intent, and I think Chair Washburn got it exactly right, the intent behind 67.32 was for those entities that weren't a policy body or a city department, and so weren't subject to Article 2 or Article 3 of the ordinance because they weren't created by the city and weren't part of the city, but to which or with which the city has ongoing relationships. And, in particular, there was concern at the time about the Presidio Trust and the secrecy around that. What the intent behind 67.32 was that city officials and officers and employees in dealing with those agencies should be open and public, should make any communications with those agencies open and public, and should affirmatively attempt to get those agencies to be as open and public as we would like. That's, succeeded to greater and lesser degrees, but that was what 67.32 was about. There is, hold on. There is similar language to the language that I quoted from state law about housing authorities generally that's in the city charter that says, for example, there shall be a commission on the environment, or there shall be a public library commission. So the operative language in the definition section 67.3 is if it's created by. And so the question is really, what is creation? I suspect that's been argued elsewhere. But in this context, it's really who creates the body. And if it's something that's strictly a municipal affair that the city creates, like the Library Commission, like the MTA, like a Planning Commission, that's a city body, and those are city records and city meetings. If it's something that's created by state law and exists in the region or exists in every county, and it's created by the state, and my read, and Member Hefner was concurring, is that the state created these housing authorities in order to access federal funds for dilapidated housing and other related purposes. And even if it requires a local action to activate, facilitate, such bodies to act, their creation was still a creature of state law, and they're still state-created local agencies for those purposes. And I think the LA Housing Authority case is probably on point on that, and I think there was another citation as well. So that's just the kind of the bottom line. I'm sorry. And I'm not saying that there aren't concerns, and I suggested earlier that Mr. Kelly has at least two avenues of recourse with regard to his public records request. We're just not one of them.
And perhaps working, so Ms. Martin, if you could, if you would address us, please.
Yeah, I just wanted to add that under 67.3, the Housing Authority doesn't fall under the definition of the policy body. Just going back to the history, the city attorney has issued legal opinions on this in the past, and they have found over and over that the SFHA is an entity separate from the city and county of San Francisco and was formed under state law, not city charter. And just in going to Commissioner Wolf's comment, the commissioners are appointed by the mayor, but in making the appointments, the mayor is performing a state function that's authorized under state law and not by the San Francisco Charter. The powers of the appointed commissioners do not come from the San Francisco Charter, but from the California housing law. When performing their duties, the commissioners are acting under the authority granted by the California Housing Authority law, and as such, neither the SFHA nor its commissioners are subject to the ordinance or the Sunshine Ordinance Task Force. So
while I have you here at the podium, I know you mentioned that you had worked some with Mr. Kelly and with regard to his request, and I want to urge you to see if there are other ways, if you can continue to work with him, help point him to where he can find the information that he's interested in. He, obviously he needs this information, wants it. He's been very persistent and has, like I said, done an excellent analysis of the issues. So I would hope you would work with him to find some way to help him obtain the information that he needs.
Yeah, we've continued to work with Mr. Kelly in good faith, but again, if the records don't exist, it's a different issue to create records.
We understand that as
well. But we are working with Mr. Kelly in good faith, and we've worked with him probably 2 years now. And as Mr. Kelly mentioned, he is familiar with the writ of mandate process, which we went through last year, and prevailed on that as well with the court.
Okay, all right. So at this time, we have a motion. Certainly. We've already heard public comment from you on this.
She got another shot after her presentation was over. And she shouldn't speak.
Excuse me, Mr. Warfield. We asked her. We wanted to hear from the parties here.
I wanted to cite one thing about initiative, which is item 4.
Sir. To be fair, we've already taken public comment.
I have a point of order, Madam Chair.
Please.
I'd like to know.
On the microphone, please.
Thank you, sorry. I would like to know whether it's appropriate for a member of this task force to make a motion that he or she intends to vote against. And that would apply to anybody who seconded the motion as well.
Okay.
I can answer your question. There was no malicious intent, and I could see why you would think that, but we need a final resolution on this, and we asked that they originally proposed a motion to affirmatively deny jurisdiction. When that didn't pass, that would essentially, without any finding on jurisdiction, would just essentially leave your matter in purgatory, which they didn't want to do. So they wanted to vote on something they could get an affirmative answer on, so they would know whether or not they do or do not have jurisdiction. Jurisdiction was never going to be found today. The fact of the matter is we have a bare minimum of quorum, so we need full. In order to find jurisdiction, we would need a unanimous vote. Since it wasn't going to be found, they needed to, in order to make sure that your matter wasn't just sitting in purgatory, they needed to, reword the motion so we could get a final resolution on the matter.
Great.
That's all it was.
Well, I regard it as nefarious because it's a way of moving my case off your agenda that is improper. My question to you is this: what happens normally when you have a vote that does not get sufficient number to pass on a particular question?
On jurisdiction?
No, on jurisdiction or just the merits of a complaint.
It fails.
The matter fails.
So under those circumstances, the complainant would lose.
Exactly. The motion fails.
Okay, so in this case, that there is.
Let me explain. In this case, we did something very rare where somebody, instead of making a motion to find jurisdiction, they made a motion to affirmatively deny jurisdiction. So that doesn't dispose of the matter by not finding to affirmatively dispose of your matter. So in order to have some sort of a resolution, somebody proposed something else in a way that, well, would more than likely make sure that we had some sort of final resolution coming here today. Okay. That's all it was.
Well, it seems to me that that's a backwards way of doing things, and that it doesn't reflect well on this commission. And I think it's more appropriate if the commission can't get a motion that it does not have jurisdiction in this case, that the matter be continued to a time when there is a sufficient quorum to get a proper vote on my case.
Your opinion's on the record now. Thank you.
All right, so we have a motion before us. We've heard public comment. Mr. Young, would you call the roll?
The motion was made by Member Fisher. Who was the second?
Member Hinsey.
Motion was to find jurisdiction. On that motion, Member Wolf.
Pass.
Member Pilpil.
No.
Pilpil, no. Member Hepner.
No.
Hepner, no. Member Haynes absent. Member Fisher.
No.
Fisher, no. Member Hinsey.
No.
Hinsey, no. Vice Chair Hyland, absent. Member Copra, absent. Chair Washburn.
No.
Washburn, no. Member Wolf.
No.
Wolf, no. The motion passes. The motion to find jurisdiction does not pass. By a vote of 0-6.
Madam Chair, I would suggest that we have not found jurisdiction and that we conclude the matter.
Well, yes, that's what that vote meant.
There we go.
Next on the agenda, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction but not on today's agenda.
I don't know if this is on the agenda, but I do have a point of information to ask. Does every matter before the body today have to pass unanimously or fail? Is that what the city attorney told us? That's
yes.
Thank you. Unanimous or fails?
Because we have bare quorum minimum, yeah.
For substantive matters, procedural matters.
For substantive matters.
Peter Warfield, Library Users Association. Later on the agenda, you have a discussion of changes to the complaint procedure, so I will not comment on the complaint procedure itself at this time. However, it seems to me that the larger process of presumably getting some degree of justice for the public needs additional consideration. One of the things that I think causes more violations and probably more complaints is when your actions are weak with respect to violators with respect to those that you've issued orders of determination against. So I think that we've all heard about the limitations about enforcement that you work under, but I think there's a great deal that you can do and can probably think of doing to give great deal more visibility to violations and violators. I think, for example, you could put onto your website a clear accounting of who has violated and in what way, rather than having orders of determination buried in a link that then is rather difficult to go through, and seeing one order of determination after another and having to read through it and so on is a lot more tricky and a lot slower than seeing something, for example, like an administrator's report. Second, you seem to have no willingness to deal with scofflaws. Over and over again from various departments, you get the same violations over and over again in different incidents, and it just keeps going on. You need to deal with those scofflaw, repeat violators, not by excluding complaints, but rather by taking a stronger approach to the violators. And that would certainly include a report to the supervisors, which you're presumably doing from time to time, as I've read previously from your larger responsibilities, identifying who are repeat violators or what are repeat problems within the city. Thank you.
Thank you. Is there additional public comment on matters that are not on today's agenda? Okay. Seeing none, Mr. Young, would you call the next item on the agenda?
Item number 5 has been withdrawn. Item number 6 has been withdrawn. Item number 7, file number 15081, complaint filed by the Library Users Association against the City Librarian Luis Herrera and the San Francisco Public Library for allegedly violating Administrative Code Section 67.21 and 67.22 for failure to respond to a request for public records in a timely and or complete manner during normal and reasonable hours of operations without unreasonable delay and without requiring an appointment in regards to bibliocommons.
All right.
Find jurisdiction.
At this time, is there a motion to find jurisdiction?
This is 15051?
Yes.
It's 15081.
8-1.
All right, so we're skipping those.
Item number 7.
Thank you.
297.
Is there a motion to find jurisdiction?
297.
So moved.
Is there a second? All right. Is there any public comment on this motion to find jurisdiction? Seeing none, without objection?
Sure.
All right. At this time, the complainant, Mr. Warfield, for the Library Users Association, you have 5 minutes to explain this matter to us.
I'm Peter Warfield, Executive Director of Library Users Association. I understand there has been no explanation of why there are 3 absences. 1/3 of your appointees are not here.
Speak to the complaint.
And so I would ask for a continuance to a time, as one of your own members said earlier, till there are more of your current members present. I think a 6-member presence, meaning 100% vote, is insuperable. It's a supermajority that is just not fair to the complainant. Furthermore, one of your members is somebody who we have spoken about publicly before you as not being capable of impartiality, and others have said similar things. So I would like to ask for a continuance to a time when, preferably soon, the attendance here will not be 1/3 absent of the appointed members.
All right.
And I would say that I would prefer a continuance, but if you don't want to give a continuance, which I think is, you have said was routine, then I would certainly consider withdrawing the complaint and refiling it. It's just not fair to the complainant to have a 2/3 putt-putt, plus the two members who are not even, where there are open seats.
So, Mr. Warfield, this is your first request for continuance on this matter?
If you count, she asked me, so I would appreciate if the administrator and the deputy city attorney would not make signals. She asked me, so I would like to answer.
Go ahead.
Previously, once before, in plenty of time for you not to schedule the 4 complaints, which you had previously put on the July agenda, we asked to have them not heard July 1st, and that was granted. I don't know if it's a continuance when somebody asks before a thing is on the agenda. If you count that, then this would be a second request. If you don't, this is certainly the first time I've come before you on this matter asking for a vote on a continuance.
So at this point, I'd like to ask Mr. Young, so these items were never actually on an agenda?
They were scheduled, the complainant was notified, provided a notice of hearing for July the 1st, and I received a request to continue the matter from the July 1st meeting, and therefore I removed it from the agenda.
So this was an agenda that I had seen and approved?
Yes.
Okay.
No, the July 1st agenda never went public.
Notice of
published.
hearing was provided to the complainant.
In the packet at page 333. Madam Chair, I would suggest that a motion for a continuance, well, that a continuance at this time would require a motion, second, and 4 votes. And if that happens, it's continued, and if not, then we would proceed with the hearing.
Through the chair.
Okay, just a second. I want to look at. I'm interested in the history of this item. So, page 333 of the packet. So, in mid-June, a notice went out to all the parties that were scheduled for the July 1st. Okay.
And we promptly replied that we wanted not to go forward on July 1st. And so the published agenda never showed those complaints.
No,
presumably you had something else on the agenda.
Right. I think you raised a point earlier about our complaint procedures. They are they're in the works, and we're still trying to, with deliberation, finalize them. But I guess my thinking is a continuance that's requested, in the few days before the hearing or at the time of the hearing is one where we would say, okay, there's been one continuance. And I know it's a fine point here, but so this is a bit, so that first continuance was way in advance, and it wasn't a matter of one of the last minute requests, which we frequently get. That's true, right?
Yes.
Okay. All right. So do the members understand what I'm saying? Member Wolf.
I mean, it seems like essentially it was about 1 to 2 business days after being notified of when the hearing was scheduled that he asked to be rescheduled. And so that to me doesn't really seem like a continuance in the way that we've discussed them. That seems like making an appointment and saying, actually, no, that day doesn't work for me. Can we do another month?
Okay, that's how I'm thinking about it as well. All right. The other issue is quorum. It is true we are down 2 members. We have people nominated for those seats, and there's a 3rd seat, too, that needs to be filled. But they haven't been They haven't appeared before rules, so they haven't been appointed. We have some people out today for legitimate reasons. And when we didn't anticipate that we would only have 6 people here until late in the day. I'm just concerned about the precedence of someone saying, oh, there are only 6 or 7 people here, and everybody saying, I don't want to be heard, and I want to wait till there are more people here. We do the best we can. We're volunteers. Things happen. So I'm just speaking my mind right now, trying to offer my thoughts. Members? Member Wolf, then Member Pilpel.
I mean, I think all of these things are really important points, but as Peter Warfield explained, and I think that he has the power to do this. If we don't continue it, he's just going to withdraw it and refile it. So I'm not sure how much power we really have here.
You do not have to accept a withdrawal if you don't want to.
Okay, I guess that's where our power lies.
Member Pilpel.
As I suggested earlier, I think continuance would require a motion, a second, and 4 votes. Absent that, I think we can proceed with the hearing, and my inclination is to proceed with the hearing if it appears after the hearing that there is some support for the complainant, but not sufficient votes to find a violation. We could continue the matter to a future meeting. I think the complainant is present, the respondent is present, we're here, and we should hear the substance of the matter. I'd like to do that.
Member Hebner.
I think we gave Mr. Kelly, his appropriate time, and I don't see any difference here with Mr. Warfield.
I likewise think that we would need a motion for the continuance. I'm prepared to hear this matter today. I was prepared to hear all 4 matters today. I think we should move forward. I'm as a middle ground, if somebody strongly feels that we should continue the matter for a discussion with more members present at some point, maybe that moment comes down the line, but
All right, is there...
I have a clarification question.
Right, Member Fisher.
What is the motion?
There's no motion
There's
on the
no
table.
motion.
So then let me back off, or maybe back up. If I'm hearing right, Mr. Warfield would like to wait, get a continuance, which means he doesn't have to file it, meaning it automatically goes to, I guess, the October meeting or the November meeting?
To be determined.
A to be determined meeting?
You would make a decision on that date as a task force.
So we would say, we would award the continuance, and then we would say, okay, it's going to go to the October blah, blah, blah meeting.
No, I'm getting frustrated because, first of all, we should have more members here. Not with you, Member Fisher, but we should have more members, and we should have more than quorum. I'm also frustrated because we prepared for 4 complaints today, and I took time off of work today to be here to hear this complaint, and I don't want a complainant to unilaterally deny us quorum, which we actually have effectively by compelling our continuance. So I feel strongly that we should proceed with the complaint.
Member Wolf.
Where I'm torn here is that we've typically had a unilateral, you've described it as a policy earlier in this meeting of accepting the first continuance. Whether he's asking for the continuance because we don't have quorum or because he doesn't like Victor's tie, it doesn't really, we've established this policy. If that's the policy we actually want to work from, I feel that he's acting within that policy. If we wanted to establish this as a case-by-case basis, I think there's latitude here, but with establishing that as the policy that we're accepting the first continuance asked, I don't think that the June 17th request to reschedule should be considered a continuance, and I feel that if that's the policy, we should honor that continuance, and I'll go ahead and make a motion for a continuance.
Okay, is there a second?
What's this motion?
A motion to continue the matter.
The argument being that just earlier in the meeting, I explained that we have this.
I'm going to second that, and for the record, I'm going to say because the earlier continuance we had was because the person was not here. I mean, Mr. Warfield shows up every time, so I'm willing to give him a break this time.
I'd like to hear from,
tabled.
I'd like to hear from,
The motion,
hi.
just to state, the motion is to continue the matter. This is a procedural issue, so we would need a vote of the majority of the members present to approve the matter.
Or if it's 3-3, then it still passes.
Then it fails.
Then it fails. The
That
motion
fails.
fails if it's 3-3.
Is your motion to continue it to the call of the chair?
I believe the
Yes.
motion will be to continue it to the October 7th meeting of the Sunshine Ordinance Task Force.
4 is the magic number in this case, then, for it to pass.
so I'd like to hear from the respondent, Ms.
We
Bachman.
need 4
please.
votes.
We need 4.
Thank you. Sue Blackman, Library Commission Secretary and Custodian of Records. Excuse me. We were prepared for the July meeting. We were noticed that that was going to be on the agenda, and we were prepared for the July meeting. That was continued to this meeting, and we are here again today, prepared to discuss the issue. We do not have staff available at your next meeting in October. So if it is continued, we would request that it be continued until November when we have the staff available.
Thank you. All right, is there any public comment on the motion to continue this matter?
It's now evening, so good evening, task force members. I've come to speak in favor of the grant of the continuance. It seems to me Mr. Warfield has a very reasonable request, and that the numbers on the task force at this time present such a situation that a continuance is appropriate. Thank you.
Thank you. Is there additional public comment on the motion? Okay, Member Pilpil.
Could I just clarify with Member Fisher?
Please.
I heard both call of the chair and the October meeting, and now I heard that they're not available. So could you just clarify if your motion
I didn't
is...
make the
I'm
motion.
the one that made the motion, and
Sorry, I apologize.
I intended to make it to call with the chair,
That's
so I'm
fine.
sticking to call with the chair.
That makes sense. Thank you.
And if maybe through the chair might take into account everything that she's heard presented by
Absolutely.
the city
Yeah,
people sitting
okay.
there in the front row.
All right.
The library people, sorry.
All right.
The motion is to continue the matter to the call of chair, made by Member Wolf, seconded by Member Fisher. On that motion, Member Wolf.
Aye.
Wolf, aye. Member Pilpil.
No.
Pilpil, no. Member Hepner.
No.
Hepner, no. Member Fisher.
Yes.
Fisher, yes. Member Hinsey.
Aye.
Hinsey, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes by a vote of 4-2.
All right, so the matter is continued to November.
Surprising.
The call is continued to the call of the chair, and the
Chair.
chair has decided to continue the matter to the November meeting, which is November the 4th.
Okay. I just wanted to briefly say to members that this idea of a quorum and the number of votes needed to find a violation came up in the past for the task force, and for a while we changed our bylaws so that a matter of substance could be passed on a majority. And consequently, it didn't work out well. It did not work out well. No, it did not work out. I was one of the people who hung out. I've never changed my mind on this, so just to let you know that I think our current bylaws are wrong. I still maintain that, but we have them. Just a matter of history. And Mr. Warfield, and then we'll move on.
First of all, thank you.
There's no need
Second.
for additional comment. The matter has been continued.
Yeah, there's no more comment. But you're welcome, but there's no more.
Okay, the members want to move on.
I did hear that you had approved going to November, and I hadn't heard that. So I'd like to clarify that.
Well, it'll be to the call of the chair. We know that the library won't be available in October, so it'll be on the November agenda.
Okay.
The November
Thank you.
4th meeting of the Sunshine Ordinance Task Force.
Okay. And by then, we'll have more of us here.
Maybe, maybe not.
Or maybe not. This is,
And I just wanted to clarify, I consider when I send out a notice of hearing, the matter is scheduled,
Right.
and any request to not be on that agenda anymore is continued to be a continuance request. I just want to make that very clear.
okay.
So I missed
Is
that.
that clear in the current, the new, will that be clear in the new?
That has never
complaint
been an
procedure?
issue, but once I notify a person of the hearing date, that is set. I do not send out an agenda until approximately 3 days before the meeting, but all members are notified of the meeting, and that
Sure.
is considered to be notice of hearing, and it is on the agenda.
Okay, thanks for that. Maybe the complaint procedure will,
We can talk about that under item 10.
right, can really nail that down. Member Wolf?
I mean, I completely understand how that's coming from, and maybe we need two types of continuances, or alternatively, which seems like not the solution, because these people have, you let them know that they've been scheduled for a hearing, but they hadn't confirmed their availability for that particular day of the month before being notified by you, correct?
I do not ask if members are available for meeting, otherwise,
It would make your work way more complicated.
yes.
So to that end, it seems like if someone notifies that they can't attend within like 72 hours of being told when the hearing is, we really should look at that differently than these people that notify us of a continuance the last minute or the day before, or these things once it's already once city staff have already planned to come and taken their time off, and maybe they had planned by July, but there still was 2 weeks ahead of time before that was scheduled.
No, I see what you're saying, and I see the distinction. I think it's an important one, but I think it's something we can address in the complaint procedure.
Yes, definitely.
Let's continue the discussion.
Let's get going.
Next on the agenda, item number 9, file number 15098, complaint filed by Anonymous against Karen Strauss and the San Francisco Public Library for allegedly violating Administrative Code Sunshine Ordinance Section 67.21 and 67.25 for failure to respond to immediate disclosure request in a timely and/or complete manner.
Motion to find jurisdiction.
Is there a second?
Second.
All right. Is there any public comment on
Wait a
motion to
second.
find jurisdiction?
There is no public comment on jurisdiction.
Without objection?
Didn't we find jurisdiction just by you?
The motion to find jurisdiction passes without objection.
Whole different case.
Okay.
All right. At this time, we will hear the complaint on its merits. So, Anonymous, would you present your side of the complaint? You have 5 minutes to do so.
I'd like to point out, first off, that the copy of the immediate disclosure request in your packet, is flawed in that it does not have a return address on it. Now, I don't know if that's part of the anonymous part of this, but this was faxed to Karen Strauss. Everything else is correct on that, April 2nd. And I have a copy in my computer that has the post office box in. The library did respond by saying there are no records should I read it? That are responsive to your request. Now, clearly, that is a false statement because in your excuse me, I should get. Does it work?
It should work, yes.
If you can just reference the page, members,
We have everything.
We have copies of the packet
Page
ourselves.
73. Page 372, 2 pages. On those pages, you'll find photocopies of documents that the library itself produced that contained the name of the person identified in the immediate disclosure request, asking for records under that person's name. In other words, the documents on those pages contradict the letter from the library saying we have no records responsive to your request. So, to use a strong language, we could say the library lied to me, or we could say the library just was mistaken, but I think they're clearly in violation of the Sunshine Ordinance because they did not produce documents they had when requested to do so. I don't know how I could be any clearer about the nature of the complaint. I'm sufficiently new at this to ask if you want to ask me questions
Not yet.
to clarify that.
Well, we'll have questions for you after we hear from the respondent.
Okay. I think the issue is very clear. I made that immediate disclosure request on April 2nd by faxing it to the chief of the Maine, and I got a response from the chief of the Maine stating that the library has searched our records and we have found no responsive records to this request. That's clearly indicating that they can't find records that part of the library knows is there because they gave it to me, and you have a I'm repeating myself. If you have a copy of those records that the library itself produced. So one hand doesn't know what the left hand doesn't know what the right hand is doing. That's not my problem. It's their problem, and I think they're violating the Sunshine Ordinance. I really don't know what else to say, except I could repeat myself, but I think that would be redundant.
Okay, we'll undoubtedly have questions for you, so you'll have a chance to respond to them and to offer any closing comments after we hear from the respondent. So, is there someone here from the library? Oh, I forgot to ask if there was anyone offering facts and evidence in support of the complainant. Okay, seeing none. The respondent, you have 5 minutes as well.
Good evening, task force members. Good evening, Madam Chair. My name is Michael Lambert. I'm the Deputy City Librarian for the San Francisco Public Library. In Mr. Pasquariello's request for complete copies of all emails, records, correspondence, notes, letters, and communications in the possession of the library, including but not limited to the Office of the Maine and the Security Department, the library responded that we had no responsive records to this request. As for the receipts that were photocopied and included in your packet that list items that are checked out, the library received, it's my understanding, the library received this request for information anonymously. Is that correct?
No, it was by fax.
It was by fax. So the records in our patron database are governed by our privacy policy and state law, the Sunshine Ordinance Task Force. I've got a copy of our privacy policy so I can speak to this. The library considers patron borrowing records very confidential because we want to protect people's freedom to inquire. It's a core value of librarianship, this notion of intellectual freedom, that people can seek information without fear of reprisal or fear that their borrowing habits, their reading habits are going to be subject to public perusal. So the each individual patron has the ability to log in through our website and access their own borrowing record, but for us to turn over these records, we would require to the individual whose record they belong to, we would require the library card during a public service transaction at the desk or a photo ID, but we would not turn over those records through a fax transmission to someone who may or may not be the owner of that account. when I've reviewed the state law that governs library records, it's very clear about the confidentiality of such records. And let me see if I can find that. What did I do with it? Okay, so the library's privacy policy references that library records are protected under California Government Code Title I, Division 7, Sections 6250 through 6270, Chapter 3.5. And the library states very clearly that we will keep all such information that it purposely or inadvertently collects or maintains confidential to the fullest extent permitted by federal, state, and local law, including the California Public Records Act, the Sunshine Ordinance, and the USA Patriot Act. Protection of confidentiality includes database search records, circulation records, and the library protects library user account information by placing it on a secure server. When we received this request for information, it did not even occur to us that this individual was speaking of their borrowing records. We searched our security department's incident database. We searched the records in the Office of the Main, but it never even occurred to us that this individual was requesting their borrowing record, and we would not have provided that information in this fashion anyhow, per our library privacy policy.
All right. At this time, the matter is with the task force for questions for both parties. Member Pilpel.
So to Mr. Lambert.
Yes, sir.
So first of all, the library's response to Mr. Pasquarello, which was, according to your letter, mailed on April 14th, that wasn't provided to us. Furthermore, the privacy policy that you were just referencing, that wasn't provided to us. And the citation in that policy is just a generic citation to the Public Records Act generally. I didn't hear a specific citation to a code section covering confidentiality of borrower information. If you have that, I'd be interested in hearing that.
Yes, sir.
And I guess where I'm going with this, it seems to me that at a minimum there's a timeliness violation here. I get that the request from Mr. Pasquarello was a little confusing and said that he reserved the right and option to personally pick up the documents at the library, but it also said above that, please mail these records to the above P.O. Box address. So that seemed pretty clear to me. Should have been the next day. Either we have, we don't, we're looking, something. Didn't happen. And with regard to his request, I sort of read that broadly. Mr. Pasquarello is not a dumb person. He asked for complete copies of all emails, records, correspondence, notes, letters, and communications, et cetera, et cetera. Even if you found no communications, letters, notes, correspondence, or emails, which seems plausible to me, records is a broad category and as defined includes all kinds of things. It would seem to me that it includes borrower records, so that's a type of record. Certainly it's data that you have in a system, whatever, it's public information, it's a record. Whether you decline to disclose that pursuant to appropriate law and citing whatever, that may make sense, may not, I don't know. But you certainly didn't, it appears that you didn't do that search or include that in the ambit of the search. I could further get with the idea, I'll take a look at that in a sec. I could get with the idea that your borrower records aren't available to me for whatever basis. I'm not sure that I get with the idea that my borrower records aren't available to me if I request them. I don't know what information you keep about a borrower in terms of their identity, address, da-da-da. I assume, and maybe I'm wrong in making this assumption, that you could determine that it was actually Mr. Pasquarello that was making this request, and that was actually his records that he was looking for whatever reason. And if you couldn't, perhaps a generic paragraph in the response letter saying, we have found no specific items in terms of email correspondence, blah, blah, blah. If you're looking for borrower records, those are covered separately. We would need to know that it's you, and there's a process, and here's how you do it. If we can determine that it's you, da-da-da. And by the way, either we looked and we don't have anything, or we looked and we may have something, here's how, blah, blah, blah. And none of that appears to have happened here for whatever reason, da-da-da. So I'm just sort of sharing with you if you wanted to comment back. I'm likely to end up with a timeliness violation and possibly a substantive violation on the scope of the search and the failure to include the borrower stuff.
Failure to assist.
Yeah, failure to assist and/or failure to produce or to note that there may be responsive records, and that either you're providing them not because of a reason, or that there's a process to get at them. But
I'm going to ask.
Sure, and then Member Wolf, did you have a question?
and I'd like to hear from the library
first, and then I'll.
Pardon me?
I think we should allow the library to answer.
Sure, okay.
Can
all
I,
right.
can I, since they were there, can I throw my question in too? Where did this receipt come from? That way we can answer everything at once.
I think when a patron borrows stuff, they check it out and they get a little
so
receipt.
it was
and
just,
he was,
yeah. 'Cause I have scads of those in my book at home.
You must be a borrower.
I want to address the timeliness. I do admit it was held back because I misunderstood the communication. I thought that he was going to come in and get it, and so it got mailed late. However, as far as I could read, that was not even part of his complaint, and he did not address that part of it. He did acknowledge that he received a response, and that the response said there were no responsive documents. So having said that, I'm the custodian of records. I have the records that the library has in our administration, in our security, in our main. Those are the records I address. As Michael said, I didn't even consider his library card records because those are not public records. They are not something that I would ever address. So it was something that we hadn't even considered. But he is correct. He obviously knows where to get those records, and I'm not saying that we shouldn't have helped him with that, but it was something we didn't even consider because they are not public records.
Okay.
Can I just interject?
Well,
I think they are public records.
But
Whether they're subject to disclosure or not is a different question, but I think, let's be clear, they are public records.
So I understand, Ms. Blackman, that you didn't think of them as that, but the way to think about records that the library has is that they're all public, but some of them are not subject to disclosure. Another to certain people. So you would not, you're right, you would not want to give the complainant's records to me, ever. You can give them to him. And if you couldn't give them to me, you would have to tell me, I can't give them to you because of these are private, private records not to be disclosed to anyone for the very good reasons that you mentioned. And I can remember the old days of after 9/11 when people were going after library records, and the library was so strong in standing up to all of that. So, but the way to think about it going forward is all of it's public, some of it is also private and can't be disclosed. But I do understand that you may not, given that you think about these records in that way, that you didn't think that they fell within his list. I do get that. All right. Member Wolf.
I mean, I'm a little confused around what exactly it means that the actual records of his library usage is a public record. So by that same token, is your medical file in SF General a public record that's also censored from public, like a private public record?
DCA COLA, you
I think if
answered
you
it.
have records that are responsive to any requests, you would have to acknowledge that and say, I'm either providing you with these records or I'm not. And if you're not providing them, you need to state a reason why. Also, the complainant did make the request anonymously. Now,
They made the complaint anonymously.
the complaint
request
anonymously.
was
the,
not
the
anonymous.
request. Okay, but even in the event that if someone made an anonymous request for their own records, or even made a public records request openly for their own records that aren't subject to public records laws, providing them pursuant to those public records laws then opens it up to disclosure for anyone else that would ask for them. So, for instance, we've had people come in here and ask for labor for their personnel file from their employers, and under the PRA request, and they said, no, we won't do that, but we could give it to you under the labor code, because if we gave it to you under the PRA, you'd have to sign a waiver, and then anyone else could ask for them.
Okay.
Yeah.
And where I was going with the question regarding SF General records, because I don't think this really applies with the library, is that essentially in this case, you would be able to ascertain whether or not someone had ever gotten a library card by asking whether there were any records subject to their name, because then if there were no records, then that meant that they had no library card, and if there were, then you'd have to say that there are, but it's protected information. This really probably is absurd in the context of a library, but not necessarily when it comes to whether or not someone has ever received care at San Francisco General Hospital, and that's where my concern over how this actually should be balanced is. It does seem like there definitely is a timeliness violation. I think it sounds like we're probably inclined to find that. And I don't know whether this rises to a violation, but in terms of the response to the letter, I think that it would have been much better to have explicitly said we have found no responsive public records to this request, or explaining that the records that you're looking for are only the public records, whether or not the definition of these essentially client records that are protected fall under public documents or not, which they may. I just trying to wrap my head around that.
Member Pilpel.
Yeah, and I think I'm generally in agreement. I'm not sure that I want to get to the SF General and medical records thing right this second, but just in terms of library, yeah, I think no, we're not going to get into that tonight.
Going there.
Right. If I could just request of the library, I'll give Victor this for the file. If you could provide us a copy of the privacy policy kind of as a PDF and not HTML. I assume you've got a different version of it. And in addition, some of these other policies that are referenced here, the patron privacy inventory, what that is, that sounds interesting. I don't need it right now, just a clean thing if you can send it to Victor so that we have it. And this patron privacy FAQ, that's probably something that you also could have referred to.
Yes, sir.
Right? And the Bibliocommons and patron privacy FAQ, which may be relevant at some other point.
Absolutely.
That stuff would be helpful. And we can talk offline about those citations, because I think there may be some stuff there that could be cleaned up.
Sure.
Okay.
Thank you.
And can I just say one more thing? I get requests of this type frequently for information of public records about certain people's names. It has never been, as custodian of records, my thought to go into their library records. So, I mean, if this is something, this may be a good thing that we have this discussion and that we consider that in the future, but when I've had requests in the past, I've never gone to see if they had a library card or, any of that, unless that was specifically asked for.
Right.
So.
And then you would have to explain why you wouldn't give it to them.
Right.
Yeah, okay.
And I think it would depend on the nature and scope of the request. If they said, I'm just looking for security reports, then no. If they said, I want all records in the library, then probably.
All right, Member Wolf, and then we'll hear rebuttals from both parties.
So this question is for the library representatives. If someone filed a public records request asking if there was a record of someone's having a library card, where would that fall under your how would you approach that inquiry?
That's not a public
We would
record.
deny that.
Yeah, that's not a public record, Josh.
Well, except, I mean, the record of the library card itself is as much a public record as these other records of what he's checked out.
Well, yes, but not disclosable.
Right, so
Potentially.
Can I suggest, Member Wolf, that we don't need to reach that tonight, and there may be other legal
there is
issues?
a reason that I'm asking.
May I?
I'll give you the two most common scenarios. We do have police coming to the library sometimes to investigate crimes. It may be, a
Like
theft.
Silk Road, like the biggest bust we've had
Well,
in the
there's
history of
that.
San Francisco Library.
There is that, but we instruct law enforcement to provide a subpoena for library records when those instances arise. As far as individuals seeking information about their own library records, we teach them how to access their account online or across the public services desk. We'll be more than happy to provide them a printout of all the books
Right.
they have, but they have to prove their identity in that moment.
The question was about the existence of a library card in their name, not the records of their library transactions.
Sure, and I think I could, if that were to happen, I would say you send a response that cites 6727, saying the basis for withholding. I would also state your policy about not sharing library card information and checkout history, and say you cannot confirm or deny if someone has a library card, and this is the basis for that. That doesn't answer the question. Nobody knows if they have the library card or not, and they provided an adequate basis for refusing to answer the question.
But in doing so, that does create the element that if they're required to respond about these other records in existence, then you do have the ability to determine whether someone or not has a library card, because if someone didn't have a library card, like let's say that that Anonymous didn't have a library card, then this answer would be fully accurate. But if they did, then the answer ceases to be accurate potentially because they didn't include that there's documents that are non-disclosable in this response.
Madam Chair.
Member Pilpel.
Again, due respect to Member Wolf, I think that's beyond the scope of this request and complaint. I think there may be other privacy aspects and things to consider. Nick, much as I love him, is not counsel to the library, and I would really prefer that we just focus on what's before us. There are lots of privacy implications. There's lots of implications of your question, both to the library and to other agencies and users of public services, and I don't want to come down on that. I get that you're concerned about it. It's a legit concern. I don't think we have all that before us tonight. I think we just have this particular request and complaint.
To whatever extent we only find a timeliness violation, I completely agree with you. When it comes substantive, then these issues that I'm bringing up come back into it.
Understood, and we can get to that on motions. I'd
like to move on.
Fine.
Okay. All right. At this time, I'd like to hear from the respondents. You have 3 minutes to add any additional. No, sir. The respondents first, and then you'll have the last word. Okay.
Okay, I just want to say that it was neither of these issues that you're discussing were willful by any means. And to the point that Commissioner Wolf just made, I wouldn't even look up to see if he had a library card. So that goes to the point of me saying, again, I could say something like, you could check your library records, but I would not even look to see if he had library records, because that's not within my purview as the custodian of records.
Okay. Anything further? Okay. All right. At this time, the complainant, you have 3 minutes to give us some final thoughts.
The custodian of records said it's not within her purview to check the library records. Did I misunderstand what she just said? I made this complaint with my name and address on it for my records. If you rule that there's no violation of sunshine, you are telling me as the holder of my own library card that I don't have any right to see my records that the library holds in my name. The implications of that are very disturbing, if you should say that I don't have the right to look at my own library, to see my own library records. They were very dismissive in the manner they handled this. Just out of hand, they just dismissed it. They didn't take, I'm sure, until they got this complaint, they didn't take this seriously at all. It's obvious. Even their tone here is very dismissive. So the central issue is, does the library card holder have a right to the records that the library holds in his or her name at the library? They were completely irresponsible in addressing that issue, and I hope you are not. Please respect the law that you are here to enforce. And I'm very concerned that we got way off the subject. This has nothing to do with the hospital. It's maybe more akin to an FBI file, perhaps, where I have the right to see my FBI file. I mean, although I'm getting a little nervous and going there, too. But I think the issue is very clear, and they were very irresponsible in the way they handled it. So remember, I filed it under my name. The complaint before you is anonymous. The substance of the matter is that the library card holder has a right to see, and they should provide those. I don't have to go in, and they didn't even say that in the response. I mean, so it's obvious they're being completely dismissive. They didn't say in the response, come in, you can get them from us, XYZ procedure. They should have done all of that. Obviously, I'm concerned that this may not come out a violation against them. Thank you.
Thank you. All right, the matters with the task force.
You want a motion?
Please.
I'll move to find 2 violations, and we can sever, what's the word? Sever the items and vote on them separately if that's necessary. I would find a violation of 67.21, and it's really all of the subsections, basically for failure to conduct a reasonable search, and to the extent that there were, sorry?
Finish.
Finish. To conduct a search of all of their records, and to the extent that there were likely records that they might or might not have disclosed, to not provide justification for withholding records, and further a violation of 67.25A for failure to respond by the close of business the next business day.
Second that motion.
All right.
Can I ask a question?
Sure, Member Fisher.
So, Member Pilpel, you're saying early on you said something to the effect of by not disclosing. Are you talking about the library record of what Mr. Anonymous checked out? Is that what you're referring to?
Yeah, for failure to even check
well,
borrower
let's
records.
back up a second.
Okay.
I am a super user of the San Francisco Public Library, Go Bernal Heights. And they're very specific on their webpage. And, you go in and you log in and you go into the privacy section, and there's a little thing that you can check, enable recently returned, and they will track, you can track your own borrowing. Okay. So we don't know if Mr. Anonymous did that or not. I mean, well, maybe you can track mine, but I didn't check that box. I don't want anybody knowing what I'm checking out. So, I mean, they make it pretty clear that there's this whole privacy thing on there. So I would think sort of a reasonable assumption by the library would be, well, we don't track people's borrowing, so as Ms. Blackman said, I didn't even think to provide that. So, that's not a public record.
Like I said, we can sever the 2 items. That's not a problem. I was just going by his request, which said, among other things, all records in the possession of the library. that mention or contain his name or any variation of it. That's a broad
Are we
records request.
DCA Cola and then member
Go
Wolf.
ahead.
I get the impression that we're starting to veer off track a little bit. I'd just like to see if I can rein us back in.
Please.
Good luck. Thanks.
Now, the complainant is alleging that that they had these records and that they should have provided them pursuant to his public records request. I think what you should focus on here is that the records he requested are not, even if he's requesting them for himself, there's privacy concerns that exempt these records from public records disclosure. Now, maybe a 6721C is a little bit more applicable here because they failed to inform the requester of another mechanism by which he could obtain those records. But maybe A and B really aren't on point here. You might also want to consider 6725A because it was an IDR and it took them over 8 or 9 days to do it. I would suggest going just 6721C for failing to inform of another route that he could obtain these desired records, and 6725A. Keep it basic.
Okay, and I just wanted to add that sometimes we find violations where, in instances such as this, where it was absolutely not deliberate and a matter of, I didn't even think that these were public records. And we find these violations to educate, to say this is how the law is meant to work, and it's a de facto violation. It's not a willful issue here. But I like the idea of being specific about, I was wanting to go there too, about failure to assist. And again, it's because of the way the library was thinking about the records, that they didn't think that this was something that they should even think about disclosing. So we're saying, no, you can, under the proper procedure, which people may not know about. Member Wolf?
I mean, I definitely think we should go ahead and separate them. It's awkward when one vote becomes the deciding vote automatically in a situation. But while I think that there is a need to provide that assistance, it wasn't an assistance to obtain public information. It was an assistance to obtain private documents, and we have gone through a similar discussion around people making requests for medical documents that we don't have. It's not a public record, or it may be a public record, but it's not disclosable. And
right. That's the important point.
Well, but
and it underlies everything.
No, except that if we were to file the same. If someone were to file the same document at SF General who had been a patient at SF General, and the response was the same, I'm pretty sure that we wouldn't say that there should have been a response about how to obtain your medical records, although they might have the inclination to do that because they get that request all the time, and the library doesn't. But in terms of the actual obligations, I don't see it existing there.
All right, why don't we separate the two?
Question will be separated. Member Pelpo, do you wish to make any amendments to your motion regarding 67.21?
21C?
I definitely think there's a 21C violation. I also think that the search was curtailed, and I'm not sure, maybe Nick, can you help me? If the search wasn't sufficient, what kind of violation is that?
I'd have to look through. I know it's one of the 21s. Did they conduct a meaningful search? I'm not sure. I don't know if
I'm thinking that it's 21A, but tell me if not. And that's why I included all of 21, because if you read 21B, if the custodian believes the record or information requested is not a public record or is exempt, shall justify it by demonstrating da-da-da. So, that's, again, why I'm thinking at a minimum there's a timeliness issue. I feel that if they were not in possession, they should have assisted, so that's 21C. I don't think the search was sufficient, and if they believe that they were not public records or exempt, they should have provided justification. So I think it's all of those.
I think 21C in and of itself is sufficient. Just see. A custodian of public records shall assist a requester in identifying the existence, form, and nature of any records or information maintained by, available to, or in the custody place. I mean, I think that's sufficient right
so
there.
21C and 21A would do it? Anybody?
I don't even know if you need 21A.
I don't see 21A because
You can just see as enough.
I'm just saying,
because
so
of the way she
21,
was thinking about it.
so 21C and 25A would do the trick?
Yeah, in my head. Member Wolf, did you have?
I mean, where I'm coming from in terms of this feeling unsettling to me is that I don't think the custodian of records should be pulling up all of these people's library records to verify whether or not these library records exist. And
I'm asking for my record. I have a right to my record.
Please have a seat.
Sir?
I'm out of order, or I'll leave the room. My record. If I don't have a right to my record, you should all.
Sir, we understand
So
that.
let me just address that point real fast before continuing on. I absolutely believe that any citizen, any person who has a library card has an absolute and utter right to their library records.
Focus on that. That's what this is all about.
That's not what this is about, sir.
Excuse me. Please, sir, we're moving ahead with this.
Our jurisdiction is around public records that the public has access to. Only records that the public would have equal access to. In the case of medical records and library records of the actual operation, that is outside of the purview of the public records that are decided by the task force.
No, that's not.
No.
Yes, I mean, to the extent of if someone doesn't get their medical records turned over that they're requesting, that's not a public, that we wouldn't hear that.
We would.
We have been hearing that. We have heard them a lot.
Come on the 15th. I've got one of those, a complaint, all right?
And what have we,
Come on
how
in.
have we ruled in that?
If
instance?
somebody's requesting their own medical records, we help them navigate that search, that request.
Well, and helping them navigate that, but do we find a violation for?
If they didn't
We have found
assist.
violations
Yes, we
against SFGH and DPH for failure to assist a complainant or a requestor in obtaining their medical records through means other than public records requests. Sure.
Privacy is a dimension and a layer to all this, but it does, just because something has a privacy dimension doesn't mean that it's not a public record.
Right, it's not disclosable, unless in this case, it's disclosable to the person whose records they are, and that's why we're saying that the library should have said, ideally, your own borrowing records are available, but we need for you to come here with your ID and so forth to get them.
The whole idea about exemptions and privileges.
Right.
But there's still the element that, like, if the response had said, if you are looking for your own records, here's how you can get them, but to actually have the search involve checking for whether those records exist and the response, depending on that, seems like a very low privacy violation, but an inherent one in the process of that. For the same reason that I was asking about whether you could ask for the existence of the library card, by filing a request, you could determine whether or not someone had ever checked out a book.
I think we should stick to this case, and this gentleman was wanting his borrowing records was part of his request, and there was a way for him to get these. The library could have told him, this is what you need to do. We cannot, trust the other end of this fax machine with this information.
Right, and I'm inclined after this discussion to go with the assisting part, but in terms of the research part, I feel that opens up a chasm that we should not go anywhere near.
So I will amend my motion to 67.21C and 67.25A. And you've already requested that the question be divided, so we'll take two separate votes on that after public comment.
In regards to 21C, what portion of 21C?
Failure to assist the requester in directing
Thank you.
a request to the proper office or providing information about the
Thank you.
existence, form, nature, and quantity.
And you said 25B?
25A.
Oh, okay.
21C, 25A.
It was an IDR.
Right.
Okay, that
Right,
one's
yeah.
pretty
Does the
straightforward.
seconder
The A makes sense. I was looking at the
agree
B.
to the change, Member Hepner?
I agree.
May I take a
We
public
need to have
comment on-
public comment on, yes. Is there any public comment on the motions before us?
Entire matter.
on both?
On
Public
both,
comment.
on both of them,
Entire
please.
file.
Warfield, Executive Director of Library Users Association. This is a very sad conversation. I'm very sorry to hear it, but I think everybody needs a seminar in what's a public record. The public record, and I don't have it before me, is what the library holds. And some public records are disclosable in whole or in part, and some are not. State law does specify that, number one, registration records, which is anything that the person gave to get a card, cannot be disclosed for any agency that gets state money, if it's a library. And number two says borrowing records may not be disclosed. So the proper response from the library is we have, if it's asked, we have registration records and we have borrowing records, which the state law specifically prohibits us from giving to anybody. Certainly the motions that are here on the table should be supported, but the library also fails to understand what public records are. When Sue Blackman says she wouldn't even look for those library records, that's absurd. And she's not giving what's required in 67.26 and 67.27, withholding kept to a minimum. No record shall be withheld from disclosure in its entirety unless all information contained in it is exempt from disclosure under express provisions, and so on and so forth. And information that's exempt shall be masked, and so on. And justification requires the library and anybody else withholding any part of a record or the whole record to have specific justification and to provide it to the requester. The library did not provide to the requester on his request any information about records they held or laws under which they were justified in withholding. And that's what they should have done. And you should find them in violation as well of the proposed motions, 6721A and B and C and 25, but also 6726, withholding kept to a minimum, and especially 6727, justification of withholding. The library did not satisfy the requirements of the law in this case. And it's very clear, if you have records and you have a reason for withholding part or all of it, you've got to specify it to the requester and you've got to document it. And the library didn't do that. And that's what they should have done, and you should find them in violation of all those sections that are in your motion and the ones I have suggested. Thanks.
Okay, I just want to say something about that. I understand the reasoning for wanting to include all of these. I don't want to go there because I think we look at the beginning of the whole process, and the request was very broad, and the library could have said, we don't have anything responsive. We do have these records that there may be records that we could disclose under certain circumstances. Yeah, so, yeah. But I'd like to call the question, and Mr. Young, would you?
On the motion to find violation of 67.21C for failure to provide assistance in the for the search for record, for the records request. Member Wolf.
Aye.
Wolf, aye. Copra absent. Member Pilpil.
Aye.
Pilpil, aye. Member Hepner.
Aye.
Hepner, aye. Haynes absent. Member Fisher.
Already? Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Highland absent. Chair Washburn.
Aye.
Washburn, aye. The motion passes. On motion to find violation of 67.25A for failure to respond in a timely manner, Member Wolf.
Aye.
Wolf, aye. Copra absent. Member Pilpil.
Aye.
Pilpil, aye. Member Hepner.
Aye.
Hepner, aye. Haynes absent. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Highland absent. Chair Washburn.
Aye.
Washburn, aye. The motion passes.
Madam Chair, can I suggest that we do refer these matters so that we can take a look at their privacy policy and see how that relates?
So refer this to EOT?
I don't care which committee, but
No,
No, I think they're done. They said they were sorry. They know what they're up against here. I think they're done. Through the chair.
well,
At the call of the
no,
chair.
I think that's true that, everyone understands what's occurred here. But I'm just wondering what Member Pilpil thinks is that the library needs to do.
I have no interest in discussing the timeliness issue further. I think we've sort of discussed this at great length. I'm concerned in particular on a quick review of their privacy policy that the citation to state law isn't sufficient, and I'm interested in discussing that and perhaps a generic response to any request that they would get with regard to borrower records that addresses both Member Wolf's concerns and the concerns that you just expressed about not necessarily disclosing that they exist, but providing information about how to get those.
May I suggest it as a hearing file and not a continuation of this complaint?
That's fine. I don't care
Right,
how.
yeah, okay.
That's cool.
Yeah, I think this would be something that would be helpful to,
And I'd like to know that the library is amenable to having a discussion about their privacy policy.
I think we
I mean,
would,
shouldn't we discuss the privacy policy in public? I mean, is Mr. Lambert still out there?
Sure.
Okay.
May I ask that Member Pilpil provide hearing language so that...
I mean, and I'm happy to work with Mr. Lambert on that.
Sure.
Okay. I mean, you want the privacy policy to be good and to protect privacy and have the appropriate citations.
Absolutely.
Thank you. So no referral on the complaint, but a new hearing file.
right, and this would be...
it can be determined at a later time.
Okay, all right.
Fine.
Excuse me. Yes, absolutely, Mr. Piccarello.
Thank you. I don't think you went far enough, but you did further. You went further than I was fearful you might not. Now, please tell me what did you say here about a hearing matter or further? I didn't understand that.
No, what this is not, it's prompted by your case, but it's not a continuation of your case.
Yes.
But your case brought up some issues regarding the library's privacy policy.
Yeah.
That we're interested in learning more about it. We're interested that the citations to state law be adequate, that the library, we're interested in policies to, so the library is able to help people like yourself who want to see those records. Is there a way to, so that this type of thing doesn't happen again and people...
Thank you, Mr. Kelly.
People who make requests have them fulfilled.
So is this an informal way in which you're going to do this?
It'll be a formal hearing, but it's it'll be noticed.
I can add.
Yeah, we'll note. Why don't we note? Yeah, absolutely. It won't be your case anymore, but it'll be prompted by your case. It'll be an opportunity to educate us further, to work with the library, and we'll keep you in the loop.
Thank
Okay.
you. At a date yet to be determined?
Yep.
Yes.
I do respect the library's right to keep our records private.
Mm-hmm.
There's no doubt about that. but I want to be able to see my own record.
Yes, sir, I understand. Okay, and rightfully so.
That's probably the section that they need to add in the privacy policy.
Yeah.
That we'll protect your privacy, but you're entitled to review your records, and here's how. We'll figure that out.
Next on the agenda, item number...
Excuse me, just...
Are you good with that?
I was just going to
Mr.
say
Lambert?
that the Library Commission recently revised our library's privacy policy. I think the issue that I'm taking away from this to be instructive is that when we're responding to a public records request, we can be more specific about how to access records that may or may not exist, including someone's borrowing records. But I'm not sure that falls under our actual privacy policy, but I'm more than willing to come to your hearing and answer questions about your privacy policy. But the ratification of the library's privacy policy is governed by the Library Commission.
Sure.
Absolutely.
Right.
But if we can come up with some language to amend it, then maybe you can bring that back to the commission. And if we don't, then that's cool too. So we'll talk about it.
Okay.
Thanks.
All right.
We're
so-
not...
Could I have equal time with the other
No.
folks that you've given an
Excuse me,
opportunity to
you're not a party to the complaint, Mr. Warfield.
Oh.
We're moving on to the next agenda item.
You said the complaint was over. He gave his opinion. I'd like to say something about our interest.
They were the parties. They were the parties that we heard from.
Could we actually take a recess for 5 minutes?
Yeah, why don't we take a recess for, how about 10 minutes?
Thank you.
We're,
So the September 2nd, 2015 regular meeting of the Sunshine Ordinance Task Force is called back into session at 7:12 p.m.
Next on the agenda is item number 10, file number 14030, amendments to the Sunshine Ordinance Task Force complaint procedure. I do have an email that I provided a copy to all the members of recommendations by Alan Grossman.
When did that come in? Today?
Came in this morning.
Okay, that's cool.
So I had a chance actually to review it, and I took the time to print out and go through the complaint procedures. I found a few typos, and had a question, a substantive question. Somewhere in here. Well, maybe I didn't have any myself. But Mr. Grossman raises a number of issues that I think are worth looking at and discussing. Suggest a couple of wording changes that I think are good ones. I don't know if we want to tackle this tonight or if we want to give everyone a chance to look at what he's proposed and also take time to go through the procedures again. I think we're really close, so. Thoughts, members?
I'll defer to the better judgment of my colleagues on this.
Okay. You've got good judgment, Member Hepner. Member Wolf.
Based on sort of the conversation on continuances that came up, I'd like to sort of massage the way number 11 is written in some way, but I don't really know what the best approach at the moment is.
Could you give us a page number?
Page 387, starting on line 16.
387 is fine.
Starting on the whole continuance section, I mean, I feel like we established that a continuance is established at the point that their hearing is scheduled, as per Victor's discussion earlier. We have the 5-day rule, but then we have that we're not going to grant the second continuance. I really think that there should be a period that's sort of pre-continuance immediately after your hearing is scheduled, so that that's a sort of separate thing when it's scheduled around a time that you couldn't have done it anyhow, unless people are being advised to let Victor know when they wouldn't be available ahead of time.
But that's...
So Victor, before you draw up the agenda that you send to me for approval, do you run the dates by the complainants and respondents?
I do not.
Okay, all right. So I think Member Wolf raises an important point. I see the distinction. It's a matter of, okay, you're on the agenda and you go, wait, I'm not going to be in the country. So it wouldn't be a continuance.
The purpose of allowing the first-time continuance is to allow for that contingency. If they are not available, when I notify them of hearing, they are allowed the continuance without question.
I see, okay.
That is my theory on that matter.
Sorry. But then it's the second, it's that, like, if that happens, that's all well and good, but then if there's something that actually comes up for the continuance, now we're dealing with the second continuance where they're being punished for this.
Then it would be at the discretion of the task force to make the decision of whether or not to grant it or not.
Right, we wouldn't say, oh, this is your second request, we're not going to grant it.
I believe that it's stated on line 19 and 20, subsequent requests may be granted by a simple majority of the members present at the meeting.
Member Pilpel.
I mean, I guess 11A, B, and C could be written differently or a little better, but it's not that bad. I think perhaps if we change our practices more so than the policy, such that when Victor gets a response from the department and sends that to the complainant and says, here's the thing, do you still want a hearing? Maybe if we could add to that, something like the next likely hearing dates are blah, please let me know your availability. And so when something actually gets scheduled for a hearing, it's at times that are expected to be convenient. I don't have a huge problem with Victor granting a continuance. The problem I have is when we have something on calendar, we've read it and prepared, and then somebody, says, oh, gee, whatever. If it's a good reason, I think in the discretion or judgment of the task force, we'll consider granting it. I don't want to be boxed in to say, oh, somebody can get on the calendar and then we're all prepared and they can manipulate the process and at the last minute say, oh, I want a continuance and I'm entitled to that. That's where I'm not okay.
So if you would be okay with leaving it exactly as it is?
Or rewriting it, but again, adding that idea that when that Victor does more work with the complainant and the respondent to determine their availability so that they...
I do not believe I would ever get anything scheduled if I have to consult with both parties.
Well, or you just say these are the next dates. I will intend to schedule this at the next available date unless you advise otherwise. I mean, if someone's going to file a complaint and say, oh, and by the way, I'm not available for the next 6 months, then that's not really a viable complaint. I mean, we need to be able to hear things and process them. The idea behind the 45-day requirement was that we get things. We get a response from the department, we schedule it, and we ideally hear it within 45 days and dispose of things, good, bad, or otherwise.
Member Wolf.
I mean, I was just sort of weighing in what Victor already said, that working out the scheduling without conflicts thing is probably easier than making it easier for them to cancel immediately once it's scheduled than to have, Victor, are you available on this day? Are you available on this? It would just be a constant shuffle. I mean, I guess this still ends up with most things being up to the discretion. The only thing that this establishes as being automatic is if you request a continuance before 5 days ahead of the hearing. Otherwise, it all falls under our discretion, and I'm a little concerned as we seem to be trying to work towards some sort of guidelines or practices around when those continuances are offered. There seems to be a tendency to not want to arbitrarily do it on a case-by-case basis, and yet I feel like we're still sort of in that vein.
I don't know if there's any way around that. Yeah. I know that we want to be fair. I think we want to be fair and even-handed across the board, but still, things arise where the situation is unique. Like I think Mr. Warfield's matter tonight kind of falls in that area because of our quorum problem. I mean, I could see the argument with there have been continuances allowed already. Everybody's here, let's do it. And we said, well, I'm the one that I had the final vote. And in my mind, I thought, okay, I understand the issue here. And there was fairness for another reason, actually, because how difficult it is to get 6 individuals you have to have everybody. That's a high hurdle for the complainant. Mm-hmm. So.
While we're speaking on this matter, we currently don't allow the respondent a continuance unless the complainant agrees with it. As in today, I might have scheduled something for the public library in October, and there's no ability for them to request a continuance, even though their whole office may be out on leave. I don't know if you want to consider that or not. Any ability for the respondent to request a continuance.
Without the complainant agreeing.
Yes.
Yeah, this, beyond the first sentence of 11A, I think the requests for continuance are either party and should be, yeah, and that thing on line 26 to 29, that whole thing in 11C, I guess. I mean, bottom line is if the parties agree in advance and something is not on our calendar, that's fine. Then it's just continued. If it's on the calendar, I think they should have to provide good cause, and it's up to us. I don't know how else to say that.
Member Wolf.
I mean, it seems to me that the respondent, unless the complainant has waived the 45-day rule, doesn't the respondent unable to request a continuance because we only meet once a month, and that would almost certainly push it beyond 45 days?
Generally, yeah.
So, I mean, if we allow the respondent to issue a continuance, what does that really mean in practice?
Well, I think in practice, like 2 weeks before the meeting, Victor puts out a notice of hearing. If somebody requests a continuance 5 days, or I guess it should say at least 5 business days before the meeting, like a week before, then something that would have otherwise gone to a hearing gets pulled from the agenda, but by that time, it's too late to substitute something else. So instead of having 10 or 8 items, we end up with, 7 or 5.
No, I mean, I understand that.
That's the practical.
I'm only asking about in terms of a respondent invoking continuance and how that plays in terms of the 45-day rule if the complainant hasn't waived that.
In practical terms, I think we're more than 45 days on most of these now, and until we reduce our backlog, we're not really adhering to that, and there are really no consequences, so it's a directory provision. So I'm not sure that there's a major implication there.
The 45-day rule is something that needs to be looked at in terms of an amendment, possible amendment to the Sunshine Ordinance, because I believe that's a very difficult bar to meet, and I believe we've only met that maybe 3 complaints out of a year for very simple matters.
And do the complainants willingly waive that, or what's been
We
happening
just
there?
cannot comply with it. We are unable to comply with the 45-day rule in almost all the cases.
So should we, I guess we can't do anything about how the procedures affect that because it's still part of the,
Right.
yeah, okay.
It's part of the ordinance, right?
It's part of the ordinance that it's very difficult to comply with, if at all.
Particularly if we've got the backlog that we have and we're getting like more complaints than we're disposing. I mean,
I understand.
yeah. I'd like to dispose of things, again, good, bad, or otherwise, sooner. I don't like these things that have been hanging around for 6 months or a year. I don't think it helps anybody.
All right. I'm thinking what I'd like to do is those of us who have some minor wording, or I have some typos. It's on the tract. Yeah, you'll find them. And then to look over Mr. Grossman's memo. And one thing he has some questions about is our complaint committee procedure. And I would respectfully ask for you to, I have a copy of it, yeah. I have 2 copies of it. To look at his ideas. And we could return to this next month. Member Pilpel.
I'm fine with that. I was, pretty okay with going forward with this. I note that we still have a list at the end here somewhere of things that are still pending for the next version. I would hope in the future that we could take a first pass and then a second pass and adopt it, and then not return to this for 6 or 9 months. I mean, we've sort of had this dangling, and I'm part of the problem. I get that.
Well, I am too, because it was today that I've looked at it before, but today I really sat down and studied it. So next time, I think we should be prepared to pass a final version, a final draft of this version, knowing that the Rules Committee exists to take a look at this on an ongoing basis, and there are some issues that have been identified that are still hanging out there, but next time we don't have to decide on those. We just need to, let's take a look at the suggestions Mr. Grossman took the time to make, and if you see any more wording issues or points that aren't clear, bring those to the next meeting. But be prepared. I think we should be prepared to pass on this version.
Could I also ask, and I agree with this point of Mr. Grossman, and I will spend more time going through his detailed comments, if Nick could take a pass on this, and if there are things that can be reconciled with the law or procedure or internal, if you could give some eyes on this and give some more feedback to Victor, that would be great. And if you detect some things that raise policy questions, feel free to frame them to us so that we can address them.
Yeah.
Send me an updated Word copy of it. And I
Yes.
can put edits in.
All right.
If members of the public have other comments, I think we'd be interested
Sure.
in reading that. Let's get this right.
So let's, next month is passage of the final version. At this time, is there any public comment on the complaint procedures?
Peter Warfield. First of all, Mr. Grossman sent me the comments and asked me to give a copy to the chair and to the deputy city attorney. So I've heard that the chair got hers, but I don't hear that the deputy city attorney got his. So, second of all, this, I believe, is actually a bylaw change. You're discussing how to arrange your affairs and to conduct your routine business. These rules that you've got include roles for the chair and for the administration, and so on and so forth. And consequently, there should be at least 10 days' notice to the public as a bylaw change. I have not had a chance to, as thoroughly as I would like, make comment, and I certainly would like to make comment, but the larger overall comment I have is that this looks to me like a complaint procedure, but more like a complaint prevention. There's a whole range of things that are disadvantageous to the complainant, that provide hurdles, and that leave excessive discretion to so-called Sunshine Ordinance Task Force staff, administration, and so on. The idea that, for example, the task force wouldn't even accept a complaint until the staff approves that it has met minimum criteria, I think is really bad. It's one thing if the staff wants to assist the public in improving the complaint and so on and so forth, but to block a complaint, to delay a complaint, I think is very poor. In general, I think, I made a comment earlier at public comment, but I think in general, I'm glad you're having the discussion about continuances. I have made every effort to alert you in this round of complaints as well in advance as possible of not just your agenda date, but even your at least a day before the last time that somebody can contribute additional material for the agenda. And I think that it would behoove you to try and stretch out, certainly, the time before the agenda gets published that you lay out your proposed agenda so that everybody can, for example, say, I'm out of the country. In my case, I was expecting a hearing in May and June. All of the hearings that I was scheduled for in July were all beyond the 45 days, and things do change. So I think that people should be given a fair shot at saying, I can't make this or that. You've done it today with the library without consulting the complainant. A longer lead time would give everybody a chance, and you a chance not to waste your time with an evening where a bunch of people say, I can't make it.
Thank you. Is there additional public comment? Okay, seeing none, could we move on to the next agenda item, please?
Would you like to continue this matter to the next meeting of the task force?
Yes. Do we have a motion?
Also move.
I have a quick question.
Yes.
Is the complaint committee, it seemed like when we first discussing it that both parties needed to agree to participate in that. Is that still the process? Do all complaints go through the complaint committee at this point, or how are we?
It's at the discretion of the chair of the task force where to assign the complaints. And I listed in the administrator's report my suggestions, and unless an issue is brought up, that is generally where I schedule them.
Although the complainant can request that it be heard by the full task force.
So the reason I ask these questions now is I think that some of that information should be included in the revision to the complaint procedures, because it's ambiguous in terms of that, and it seems like that would be the place to put it.
I believe I do have a description regarding that.
That is there.
What's that?
I do have a section regarding assignment.
Which section are you referring to,
Give
Victor?
me a moment, I will find it.
Page 385 at the top, section 4 there.
But that does not explain that the complainant has the option of requesting it before the full task force.
I do not think that may not be the greatest idea to give them that much control over our agendas.
I mean, if they have that option, I mean, maybe we don't want to give them that option, but if we give them that option, I think it should be documented in our
That
procedures.
is not an official option. It's been just a general practice by the chair. But if I don't think we should give them that option, otherwise we will have. It needs to be at the discretion of the chair, just so that they can review the agendas. Otherwise, we'll have complainants controlling how we operate and how we agendize items.
I mean, I'm more than happy to work it out to whatever discretion. I just would like to see it written more in the complaint procedure.
My view of the item was that I would put it in the administrator's report upon receipt of a complaint where we anticipate we will be scheduling them, and then it'd be up to the task force to decide if at that time when they review my administrator's report, if they want to change that assignment.
So maybe,
And then we have complainants who pretty much demand that it be heard before the full task force, and we agree to that.
so maybe if we can note that B4 and C1 perhaps need a little more verbiage to explain that.
That sounds good to me.
Yeah.
But I do believe we need to leave it to the discretion of the chair for the absolute final decision. Otherwise, we will have certain people overloading the full task force agenda with.
No, it's just documenting that.
Yeah, I think it should be to the discretion of the chair. I just think it should be filled out a little more in number 4.
Yes. B4 and C1.
I will try to add more of a discretion of the chair to the issue.
So I made a motion to continue this date certain to the next meeting. I think I need a second on that.
Second.
And if I could just also make note, I think the members of the public have left, but just to be clear, this is not changing the bylaws. This is simply our complaint procedures for how complaints are handled. This is consistent with the bylaws. And I think the concern that was expressed about B2, that we have minimum criteria, and if a complaint doesn't satisfy those criteria, it won't be accepted. I think those criteria are extremely reasonable.
And our administrator works with complainants. So,
Right.
okay, I think without objection? All right.
Matters continued to the next meeting without objection. Item number 12, approval of minutes from the. I skipped one. My apologies. Item 11, hearing. Status of the Sunshine Ordinance Task Force Annual Report for 2014-2015.
All right. I explained to Victor that I hadn't done my homework, hoping to get to that this month since my teaching load is light. And I urge everybody to chip in and do their part so we can get this off the agenda.
And our part is to review this.
Your part is to
Provide a brief summary on
Committee chairs.
the
of what
committee's
the Rules
section.
Committee was doing, and
A one or two
EOT
page
has
thing.
to,
Well,
and
so we have
compliance
to-
amendments.
So, through the chair, I probably have to get that information from you, because
I'll be happy to help.
Right. And you can, yeah,
I'll call you.
and
My
you know,
people will call you.
cut and paste from, you know,
I don't
last year's,
anticipate
edit
a
last
lot
year's.
from the Rules Committee, as we're
There was
very
no Rules
basic
Committee
about
last year.
the reviewing of the procedures and bylaws and so forth. It would be relatively simple.
It's like a paragraph or two. That's
Yeah,
it.
yeah. Okay,
So I
so,
really don't think I have anything to say, other than we met on these many days, and I would need these
I
many
will
days.
try to help out.
And we had this many, and
and you did propose certain changes to
Then
the,
you created the complaint, you did the initial draft of the complaint procedures and not complaints.
Revamped the
initial draft of
bylaws.
Committee.
yeah, we did do that.
you did a lot,
You did
so.
more than you give yourself credit for.
Yeah,
We'll
we
look
did
through
do
the
that.
minutes and we'll
We'll chat.
review it.
You just tell me, and I'll write it.
So I would like to see at least one page double-spaced in, I won't ask for APA formatting, but that's your assignment.
Page double space. It was the best of times. It was the worst of times.
If we have even a rough first cut next time and we can talk about it, I don't anticipate that we would adopt it next time because we'll probably have to do a further round of revisions. But if we can just,
We undoubtedly will
Yeah.
have to do revisions, okay.
but at least we'll have something further.
Right.
Again, do you need a motion to continue?
Yes.
So moved.
We don't have any members of the public, so without objection,
Next on the agenda, item number 12, approval of minutes from the Sunshine Ordinance Task Force August 5, 2015 meeting. I have provided a revised edition of the minutes with corrections, clerical corrections made by Member Pilpil.
I have some more, but I have, they're very minor, but I have one of substance on page 7 of the minutes, page 408 of the packet, item number 17. Hearing review of the ballot measure. I guess this is now, it has a letter, it's Prop E. It looks like we didn't do anything. We actually discussed it.
Yeah, I mentioned that to Victor, where we continue an item like these last two things. For example, I think we should have at least a one-line thing that says the task force discussed the matter and just some generic.
Yeah,
something.
we recognize that we could not publicly take a position on the measure. We did discuss
Its provisions.
its provisions and implications for the ordinance and the work that we do. So something to that effect. And
Yes, I will add that.
yeah, and here's.
And same thing on item 18, for example, where we discussed the complaint procedures again. You know, the same.
Yeah, although
we had some discussion.
I don't think we discussed it very much, though. That wasn't my memory, but.
Right, fair enough.
Okay.
I
So-
may have some further edits. I already did one round, but I will so move to approve with the edits as amended.
Do I hear a second?
Second.
Seeing no members of the public, without objection.
Next on the agenda is the administrator's report. The hearing schedule for the next few months, I believe September 14th was originally scheduled for the EOTC to meet. However, I believe there are some holiday issues involved with that, and there may be a need to cancel that.
I'm sorry, I missed that. Which one?
That's the September 14th EOTC meeting.
Yeah, Rosh Hashanah is long over by then. Is that what you're getting at?
No, it's actually that day.
It's the Erev Rosh Hashanah is the 13th, right?
Yeah.
Which means you go that night.
And the next
Musaf
day.
and Shacharit and all that is done by, Tashlich is over by, well.
I haven't received an agenda from the chair of the committee yet either, so I don't know.
Who's the chair of that?
Vice Chair Highland. So
Who
I
else
will
is
work
on
with
that
member
committee?
with Vice Chair Highland to see if they wish to continue with the meeting.
I am,
Jews are on that
and Member
committee.
Wolf.
Never mind.
So,
Not practicing anything,
All right.
but
well,
Are you available for that meeting, Member Wolf,
What
if it
time?
does occur?
September 4th. Hold on 2 seconds. Yeah. I'll be available.
So I will leave that to Vice Chair Highland to make the final
The
determination
issue
on
would
that.
be if the respondents or the complainant, the public,
Yes, I'll work with the chair of the committee to see if he wants to continue with that meeting.
and
I am not going to be available that day, so if we can.
you might want to check with the clerk of the board. There might be some rule, if you will, about that, some city rule about not scheduling it on that day or something.
There's no rule.
Rule about
There's no rules
That would-
about that?
It's not
all sorts of-
a public holiday. It just is inconvenient for certain people.
Okay.
I will work with Chair Highland to decide if he wants to continue with the meeting or not.
And we should look at alternate dates that work for Member Wolf so that the three of us could make it.
What? Isn't it all like determined by when this room's available and stuff?
Victor checked on room availability. We could talk about that offline, but I just would like EOT to meet, and if it's possible that we could do it in a way that works for all three of us. That would
Yes.
be fandango.
The next meeting, the Rules Committee is scheduled to meet on September 15th. However, I will be converting that to a complaint committee meeting. Currently, we have Member Fisher and Member Hinsey. We do not have a third member of the committee at that time.
On the 15th? You can't make the 15th?
So we need 2 replacements for the 15th.
That's it.
It'll be all me, all the time. Overruled.
That's it for
You're out of order.
And I
Are there
also
any
can't.
volunteers for the meeting at this time?
And I also can't do that date. So
Is that at 4 p.m.?
Yeah, it's
Yes.
at 4.
Okay. I can't do Tuesdays or Thursdays.
I cannot.
Oh, yeah, Member Hinsey's mic is off.
Is the 14th EOT or is it complaint committee?
The 14th with the EOTC, the complaint committee was going to be on the 15th of September.
Okay.
So, Lou, you can make it?
What am I making?
The
September 15th meeting.
Yeah, but I'm all alone.
Yes,
I'm
we
going to
need
like
two
be a
additional
committee of
members.
one.
I could make it.
That's two out of
And then I will try to get a last member via, I assume no one in this room. So I will check with the other members, Member
Haynes.
and Member, but we will proceed no matter what with the two members.
Okay.
The notice of hearing has already been sent out. The next meeting of the task force is October 7th. Compliance and Amendments Committee is meeting on the 20th. I believe that they will need an additional member also, but that is quite a distance away, as Member Copra, I believe, is
Not happening.
Right. And we may have two new members.
Yes.
Let's hope.
Week is that?
Yeah, I think
Tuesday.
But that's quite a distance away, so.
the 21st is a Monday, not the 20th.
Yeah.
So that is going to be a very packed agenda again. I anticipate at least 7 or 8 items from Member Petrellis and from Complainant Petrellis and Complainant Hartz.
Oh, yeah, and I ran into Michael Petrellis yesterday. He's back in business. He's okay.
Oh, good.
Yes, he is out of the hospital.
Yeah.
Good.
And
Live.
recovering.
Oh, I didn't
Live and
know
well.
this.
And
What happened to him? Did he
I
say?
didn't
He
ask.
did
He
not
didn't
say.
say.
He blogs everything. I'm surprised he didn't blog his CAT scan.
Pull it up on
Never
his
mind.
Facebook
Pretty
right
sure he
now.
did. Actually,
In any
blog
event,
about
he
this.
wanted. He said, "Why didn't you hear my thing?" I said, "Well, we thought you were unavailable, and so."
You did him well. Why didn't you hear my thing?
I would like to schedule another complaint committee meeting for late October, but I will discuss it with the task force at the next meeting.
Okay.
I believe that's as far as I need to go for now, through October.
Right.
Can we also look, not right now, but EOT for November? I think that falls on what do you call it, Veterans Day, observed.
I'm pretty sure it does not, as I checked
Okay.
it at the beginning of the year.
All right, let's just be sure between now and then. That's cool. All right, I'm good with.
Listed under item number 3, communications, I have several letters included in the packet from Mr. Alvin Johnson regarding his various requests to not attend meetings, to have us refer matters directly to ethics, and so forth. I wanted to suggest that we schedule a meeting at the October meeting of the Sunshine Ordinance Task Force to discuss how the task force wants to handle that, to either schedule them, continue the matters, or to table all of his complaints due to his refusal to attend task force meetings. I will invite Mr. Johnson to that meeting to discuss how he wants to proceed with all of his complaints.
So you've established a hearing file that is specific to trying to determine how to handle all of his numerous complaints.
Yes. If you read his emails, his requests conflict with each other. I don't know how to handle his complaints anymore.
So I'm supportive of this effort, notwithstanding his communication about my existence. If we could just be very clear, and Nick, if you can also check on the wording so that it's appropriate, like, hearing regarding these file numbers with the option to schedule them for hearing, continue them, or dismiss them, something that gives all the options, and notifying him. And I think we should probably notify all the affected departments. So if they want to say something or send something in advance, they should feel free, and make very clear that we're not going to address the merits of the complaints at the October meeting. It's merely for discussion of handling or scheduling. Does that seem about right?
That's the purpose.
Okay.
Yeah.
I have distributed a copy of a proposed title for the next meeting of the task force regarding this matter. I will give a copy to all members if you have any additional suggestions to that.
And again, we'll notify all the departments. I'm good with
Yes.
that.
Next on my report, actually, still with the communications, we have a request from Michael Dario regarding his request for records from Stanford. If you have any comments, please provide them to me, and I will forward them to Mr. Dario.
I think I saw that. He got some press about that. There was an article in The Examiner, I think, about it.
Records from what?
He has requested
What page is this on?
papers. This is page 415, item number 3.
All right, 415.
Yes, the second bullet point under item number 3.
Right by it.
Yes, the actual communication, a copy of his communication is attached.
Wait, oh, I'm on 416. Okay.
Let me find the page.
Looking here somewhere. Page 456 of the packet. He's looking for the Dianne Feinstein papers from the 70s about how she supposedly fought the street artist program, and Stanford is saying we're not providing them right now. Kind of entertaining.
He's seeking advice from the task force. However, if you have anything you wish to communicate to him, I'd be happy to forward it.
I don't think we have jurisdiction over Stanford
We don't have
University.
jurisdiction over Stanford, but we could waive
If you would
our...
like to tell him anything, I'd be happy to forward it.
Well, I mean, that's a good question. I can't believe Stanford would say no. Fiona, make a call for us. That's your school.
Well, it's an interesting issue. The records at one time were public records here in the city.
I know. I mean,
Once public records somewhere, do they?
become private?
I don't think so.
Take a look at this and tell me what you think of that.
Well, it depends. I mean, I know my father's papers were just turned over to Yale University like 4 years ago, and you have to fill out a request. I mean, I'm his daughter, and I have to fill out
Currently
a
on
request to
deposit.
get like information about me.
And will not be determined.
Next on the
It seems like if there's records that were public city records, and then at the point that the city, they've gone beyond the city's retention policy, but they still exist, it does create an interesting thing that there may be some nexus there that the city has an obligation to. I have no idea how that works. It's weird.
Well, I know that like with the Ginsburg papers, right? I mean, he sold them because he was like destitute, and I can't remember which school he sold them to. He sold them, so they became private, but he wasn't an elected official,
Yeah,
so
they
that's a
weren't.
whole other story.
They weren't public records.
Yeah.
Well, I mean,
This is not cool. If these are elected official public records of the city mayor, although there was no sunshine ordinance in the 70s. That could
Correct.
be the other issue.
And the 80s. So, I mean, I think it goes to 29. It's Nick, help me. Is it 29-7 or? Yeah, and that records survive officials. There's a provision about records surviving officials because there was concern in 1999 when Prop G was being drafted that Willie Brown was not necessarily going to keep his papers as mayor, and I guess not specific to Michael Adario's concern, we could communicate with this mayor's office or other city officials and say, exactly how do we handle a transition of officers particularly if there are important papers, and what's the relationship to the special collections unit at the library, et cetera, et cetera.
Well, I have a two-part question. Does the sunshine ordinance, Nick, go retroactive? I mean, it passed in 99. Does it go to papers going back to 78? And on page 457, there's one line that says, their status will not be determined until the senator leaves office. Well, she's almost done anyhow. I mean, how much longer is this guy going to have to wait?
She's got another 4 years, doesn't she?
Yeah. Yep. Anyway, 3.5.
So if you have any comments
2
you
days
wish
ago.
me to
Oh, really?
provide to Mr. Dario, please let me know. I'd be happy to.
But I think that
We're
larger
stumped.
issue we should
He
still talk
stumped the
about.
host. I think we have to get a legal opinion on this from somebody.
You don't have to respond to him. It's just communications. If you wish to respond, you can. If you
I
do
would
not,
suggest
you-
that it's not retroactive, but to the extent that any of those records still exist within the city, that they shouldn't be destroyed and should be kept and da-da-da. But
if you have a
there are
response for
lot
him,
of
please
interesting
provide it to me in
questions here.
writing, and I will forward it.
And then on page 458 is,
Not a fan.
I didn't even read that yet. I just was like, okay,
Apparently not a fan.
going after my man here. All righty then.
Number 4 in my report is a list of all the complaints that were submitted, and I also listed in there where I anticipate to schedule them, assigned to complaint committee or assigned to SOTF. I believe the majority of these are going to complaint committee.
I have a comment. Through the chair.
Member Hepner?
Complaint number 15124. Respondent is Office of the City Attorney. The respondent has stated that they declined to participate at the SOTF hearings. I think we need to address this issue at some point before it starts, spreading as some type of precedent that they can adopt a very narrow view of what it, of our ability to compel departments to come before us to adjudicate certain matters under the Sunshine Ordinance. I believe what they're referring to is a very narrow interpretation of 67.21 subsection E. It says that they only need to attend if we are determining whether a record is public or not, and that if the complaint alleges a violation of any other section of the Sunshine Ordinance, they don't need to attend. I think that that's narrow and unreasonable. It's come before us a couple of times, and I think we need to address that and squash that interpretation soundly. And I'm hoping that DCA COLA can help with that a bit. But really, that's a dangerous interpretation of the Sunshine Ordinance.
And they've just started to adopt this stance, right?
And Supervisor Breed's office echoed it at the last meeting of the complaint or the compliance amendments hearing.
And I agreed to draft a letter, which I started and have not completed yet, to the city attorney, and that we will bring back to the full task force to incorporate that and the budget stuff.
Okay.
So that was what was happening.
Okay, so maybe we'll address it through that means.
And soon.
Yeah.
I get it.
Okay.
And to Victor on this point, they have stated that they won't participate. Did they state that specifically in response to this request as well? Or
I
are you
believe
just
that was in their
referencing
response to the complaint.
to this already?
To the complaint letter, to this specific complaint.
Okay. Even though the issue implicated is a public records request. So it would seem like even in their more
I'll be
narrow
happy to
interpretation-
provide you a copy of that.
Yeah, okay.
Yeah.
And then I think I had another question about and I'm forgetting it now. Right, in any event, this shows the new complaints, and including like the Moses Correct complaints were filed and then already withdrawn?
If I do know of that they have already been withdrawn, I will mark it. I believe the Moses Correct complaints have been withdrawn. I managed to get him the documents you requested, and he withdrew his complaint.
And let me just ask on 15120, I thought we had, and maybe I'm wrong, and I'll go back to the complaint procedures, I thought we were not taking anonymous complaints anymore. Are we still doing that?
I think we allowed them to file anonymously. However, I will not redact any documents that they provide to me.
That's what the complaint committee or complaint procedures say.
Okay, and we can change that or discuss it again as part of the complaint procedure. All right, but that's
But we
legitimately-
have discussed it already, so.
All right.
Next is item 6. We currently have 59 complaints pending adjudication. 22 by Alvin Johnson, 8 by Ann Trebot, 5 by Ray Hart, and 7 were scheduled for adjudication tonight.
Of which we dealt with 6, I think.
Next, a listing of what's pending before the complaint committee, of the committees of the task force. And 8 is a list of pending issues. Not much has changed to that.
So let me just ask about the item 6, the sort of workload stuff. So the 22 Alvin Johnson things, we'll have those on next time to deal with. the 8 and 5, I get that, and the 7 tonight. Okay, so that's 22 and 8 is 30, 35, 42. So that gets me to 42, so that means that there's 16 others in the pipeline, including the ones on the previous page that are still in the works?
Yes.
Okay.
Just to let the task force know, if I get no new complaints, I will have everything scheduled for hearing by the end of November.
Very good.
But you always get
But we
complaints,
will.
though.
Yeah, that's the problem.
Yes. That's why I'm trying to be sure that we schedule complaint committees at least once a month.
I'm here for you. I just can't seem to get anybody to come with me, but
I'll be there.
Okay. And then item 7 has a better description of the issues that are pending, not just the complainant. Oh, actually, it doesn't even include
It's
the
just for
complainant.
the committees.
Yeah.
Items that were referred to committee by the task force.
Okay.
That completes my report.
And on item 8.
And there's no public comment on the report.
On item 8, I still have a bunch of things I got to do. I get that. We did get the supervisor of records report. Were we going to try to schedule that next month or the
I
following?
can go over that under item 14.
Oh, okay, cool.
All right, moving on.
Thank you.
No action is taken under administrator's report. Item number 14, announcements, comments, questions, and future agenda items. I have a list of items that I will be putting on the next agenda. Annual report, the 2016 meeting schedule, committee schedule and membership, supervisors of records report, and just to let you know, September 10th, 2015 is a possible date for the Rules Committee hearing to appoint our 2 missing members.
Good. And I need to, actually, I know, Victor, that you sent me Sandra Close's contact information. I need to contact her for replacement
New American
for
Media.
New American Media.
so we have somebody in the hopper?
No, I dropped the ball on that. I need to do that.
So we're still stuck with these nearly impossible inclusion-exclusion criteria. They have to be a member of the media and a lawyer and born in a month with an L in it.
I believe this one is a recommendation from the New California Media and must be a journalist. That's just from my memory.
That's traditionally, it's been very
Not
hard.
many journalists anymore.
It's been hard to get recommendations from them, but we need to get with that.
We need a big sign, and every time somebody complains that we don't have enough people or quorum, we just need to hold up a sign that says, call New American Media, 415, blah, blah,
Yeah.
blah. I am dead serious. So I'll put a projector, and I'll just flash it on the screen.
Any other
Or that
announcements
screen
for
over
tonight?
there.
Would everybody please let me know what committee if you want to switch your committee membership, let me know. I ask every
here to learn this one. Hell no.
So it looks like the New American Media just has to be whoever they submit. It doesn't actually seem like it's required to be anyone. It's just whoever they.
No,
they
it
have to get
actually
the
has to
rules.
be
They
a
have to
journalist.
be- yeah.
Yeah,
It's specific. It's a journalist
Yeah.
from an ethnic or minority-owned news media outlet.
Where's that written down?
67.30A.
It's in 67. yeah,
it's in the ordinance.
We need to get that ordinance. I mean, if David Lee could file some brouhaha and get it on the ballot, why can't we?
We've discussed a number of times. We've discussed substantive amendments to the ordinance. At times we've come to agreement. At times we've not come to agreement, and we've not gotten it introduced at the board. Nor has there recently been any petition drive.
Well, why do we have to
amend.
do all that? Let's just hire a bunch of signature gatherers, write whatever we want, and
Okay,
move on.
I wasn't prepared to say anything about this until tonight, but the League of Women Voters has, and this was a decision by the membership, that the League would be happy to be an organization that would be the conveners, the facilitators for an effort to get an initiative on the ballot in 2016, the fall election. So the league is currently organizing itself to figure out how this is going to happen. So it's very early days, and I just wanted to let you know that this is afoot, and the league would, like I said, are the organizers. There have been many attempts by this body to draft amendments. We have all of that work. All of that work exists. There undoubtedly will be a signature gathering campaign, and we'll need all hands on deck. I'm not sure how this ordinance will, how our task force will be involved.
Well, given, as Pat co-chair of my organization, given the response that I've heard and the work that Member Hepner has done, I think if this is coming through with sort of the blessing of the Sunshine Ordinance, and that, yes, we all worked together on this. It was a collaborative effort of people coming together, and this is what we're doing. It'll be a lot better than you did what, and you're shoving it down our throats? So
yeah, no,
I think the public will,
Yeah, this will be, what the league has in mind is this will be a very public, open process, but not starting from scratch. It will bring together all of the earlier work that the task force did.
We just have to fix the things that are outdated.
Right, no, that's part of it, and cleaning up the language and resolving ambiguities and so forth. So,
let's just be careful. We're getting into a gray area of kind of opining on measures that would replace something that's already on the ballot. Yeah. Well, right.
No, this is for. No, we're not going to opine. We are not opining on anything on Prop E at all. This is. This is information about what an organization is doing, and it'll be something that we'll all hear about. So I'm
and
just
perhaps be involved with,
and be involved.
We have no opinions on any props that are on the ballot.
Right.
And
At all.
I guess then
Never.
I'll say I have done substantial work on my own set of amendments. I haven't completed all that, but I would hope that some of that could, inform the process.
Absolutely.
So we'll see how this all plays out.
Absolutely. So I've known about this this movement for some time, but the league had to decide to take this on, and so the league is not going to be drafting amendments. The league is going to be the organization to bring people together.
Because they have time for this. I mean, I guess they're a part of this organization. They're one of the recommending.
Right, and
so I guess they have to.
There are a lot of young, vibrant women who are ready to go. And then there are a lot of people who have been working on this forever who will be part of the process.
SPJ hasn't done anything. Sorry, is that yours?
I'm not the SPJ representative.
We have no SPJ representatives right now.
See, look, they're not even here.
So anyway.
Ali was the SPJ
There being no further announcements,
Who was?
Ali.
I may suggest that we adjourn the meeting.
Motion to adjourn.
The meeting is adjourned.